Good morning, ladies and gentlemen. We're back in docket number, we being the Public Service Commission of South Carolina, are back in docket number 263E. Let's take roll. Present virtually, we have Commissioner Irvin and Commissioner Caston. Present in the hearing room, we have Commissioner Thomas, Commissioner Powers, Commissioner Williams, Vice Chair Belzer, and Chairman Williams. Attorney Pringle, the floor is yours.
Thank you, Mr. Chairman. Mr. King, you still there?
I am. Thank you.
Okay. Let's very briefly go back to the discussion of the October 31st, 2018 Duke Energy Carolinas offer to Cherokee, and this attachment 4 to your Exhibit 2. That proposal, well, let me ask it this way. Would you agree with me that a must-take agreement has a different, or can have a different pricing structure than a dispatchable tolling agreement?
Yes, I would.
Okay. And in fact, the prices that were proposed by Duke Energy Carolinas in the October 31st, 2018 offer were an on-peak energy price and an off-peak energy price, correct?
That's correct.
Okay. And when, as we discussed earlier, Cherokee responded on December 7th, 2018 to that particular offer, Cherokee offered a different pricing structure than the must-take pricing structure that Duke Energy Carolinas had offered, correct?
That's correct. Yes.
Okay. And it's true also, isn't it, that Duke Energy Carolinas did not provide a response to that particular pricing structure and those particular terms to describe why that particular proposal didn't meet Duke Energy's avoided costs, did it?
Let me check the timeline. So that was the December 7th letter?
That's correct.
I believe on December 12th of 18, we sent them an email explaining that was
And you did respond with an email that said that you didn't consider those costs to be appropriate.
the response, I believe. I mean, I haven't read it recently. I can read it, but I expect what the response said, which is what was our consistent message, was that the numbers that they provided, that Ellis Power provided to us, were above our avoided costs, and we could not transact at that level.
Okay, understood. But your response didn't inform Cherokee what the avoided costs were for their particular price structure that they proposed to you in their dispatchable tolling agreement, did it?
No, it did not.
Okay. So at that point in time, even though Cherokee proposed a set of rates and prices based upon a dispatchable tolling agreement, Duke did not respond with another counteroffer or response that said, well, your prices are too high, but here's what these prices would be for this type of structure.
That's correct. At that time, as I mentioned, I think previously in 2018, because we were, trying to deal with the large QFs in a non-discriminatory fashion, where we were trying, at that point, we were offering our large QFs above 2 megawatts, a must-take agreement.
All right, understood. And subsequent to that October 2018 timeframe, and you mentioned several other offers made by Duke Energy Carolinas, it's correct, isn't it, that each of those offers was based upon Duke Energy Carolinas' avoided costs, according to Duke, at that point in time, at the time the offer was being made, correct?
That's correct.
Okay.
Well, let me say one thing. Hold on, Mr. Pringle. You said DEC. So the first offer is DEC. The second and third must-takes were DEP. But for DEC and DEP, the costs were calculated based on at the specific time we saw or received the request.
Okay. And none of those offers or the costs in those offers were based upon the proposition that Cherokee established a legally enforceable obligation in September of 2018, correct?
I apologize. What did you say about the legally enforceable obligation?
None of those subsequent offers that you've described that were based upon current avoided costs were based or calculated based upon the establishment of a legally enforceable obligation in September of 2018.
It's our position that a legally enforceable obligation was not established in 2018.
So the answer to my question is yes?
Well, you said that you established a legally enforceable. I just want to let you know that, just to make it clear, as we did in every letter we sent, it's Duke's position that a legally enforceable obligation was not made at that time.
I understand, and just to follow that up and to follow it through, as a result, none of the rates that were calculated and offered to Cherokee were based upon the existence or the establishment of a legally enforceable obligation in September of 2018.
Well, no, in September of 18, when we got the first correspondence from them, so the first offer, the October 31st, 2018 offer was based on the intent we got to sell from them in, I think it was in September of 2018. It was actually September. So what we did is each response we sent them, whether it was the first one, the second one, the third one, the fourth one, or the fifth one, were all based on the most current communication at that time, so that they are current and the rates are not stale.
Okay. Let me just clean this up, and I apologize because I'm not being specific enough with my questions. Subsequent to the offer that was made in October 31st of 2018, meaning each offer, not that offer, but each offer after that, every one of those offers was made without reference to or acknowledgement of the establishment of a legally enforceable obligation in September of 2018, correct?
The second, third, fourth, and fifth offers were not based on the September of 2018 correspondence we received from LS Power.
Okay, and therefore not based upon rates not based on rates projected at the time of that, what Cherokee calls the LEO.
The only way I know to answer that is that the second, third, and fourth, and fifth offer were not based on the September 2018 avoided cost.
or on avoided costs projected for the 2021 timeframe that Cherokee wanted to have a subsequent relationship with Duke Energy?
I think all communications that relates to term sheets and offers and that, they all assumed a 1/1/21 start date
Okay.
of the successor PPA.
Okay. All right. Well, let's move on. Is it your testimony that Duke Energy Carolinas could not offer a dispatchable tolling agreement to Cherokee in 2018?
Can you repeat that question, please?
Yes. Is it your testimony that Duke Energy Carolinas could not offer Cherokee a dispatchable tolling agreement in 2018?
It's Duke's position that at that time, to treat all large QS on a non-discriminatory basis, that we were offering must-take agreements at that time.
Okay. At that period in time, you've already testified that Cherokee was operating under a dispatchable tolling agreement, correct?
That's correct.
At that point in time, was Duke purchasing power from any qualified facility in South Carolina according to a must-take agreement?
Yes.
Was the existence of a must-take agreement and a dispatchable tolling agreement in existence? Was the existence of, strike that, was the fact that Duke was purchasing power according to a dispatchable tolling agreement on one hand and a must-take agreement on the other hand at the same time discriminatory under PURPA?
Well, I can't really answer that question. I'm sure one of our other witnesses could talk about whether that is discriminatory under PURPA, but I do know that we did have, I think, 2 other cogens working under must-take agreements at this time. And actually, I'm not aware of any other QF agreement we had that was a dispatchable tolling agreement at that time. I think everything was must-take.
Okay. Is it Duke's practice to always provide avoided costs based upon present avoided costs in these negotiations?
I think probably, witness Freund calculates our avoided costs for these processes. He might be able to answer that question better. But what we did do, even though that on multiple occasions, Ellis Power sent us correspondence in their opinion, establishing a LEO, typically we would, even if we didn't believe a LEO was established, we would still try to be responsive and provide them the avoided cost calculations. And that's why even the 3 must-take agreements varied. If you could see, when you look at the must-take agreements, the first one only had 2 energy rates in it. The next one had more, and then the next one, because though even the must-take agreements were kind of evolving with the rules in South Carolina at that time. So when we talk about the must-take agreements, actually they are must-take, but they were all 3 structured a little bit different until we eventually got to the dispatchable tolling agreement. But it is it's important for us. One of, I guess, the key tenets of this for us is that we want to make sure our avoided costs are calculated consistently amongst all QFs and that they're as current as possible and they don't get stale or become, out of date, obsolete, and so that our customers are stuck in a situation where, like they're in right now, with the current Cherokee agreement where we're paying, our customers are paying, you know, right now under Cherokee for rates that were set almost a decade ago. And it's a significant overpayment.
Okay, I understand that. Let me ask you this. I think you testified earlier. Did you testify earlier that the rates that you offered to to Cherokee in October of 2018 had been approved by this commission, by the Public Service Commission?
I don't think I ever said that.
Okay, do you know whether or not they had been?
That would probably be a good question to ask Witness Snyder.
Okay. Are you aware that the commission order, or would it surprise you that the commission order in place at that time instructed Duke Energy Carolinas to negotiate rates with large QFs like Cherokee?
I don't know what negotiate rates mean. I mean, we're like I mentioned before, based on the rules and regulations in the place that we receive a communication from a counterparty, we go ahead and calculate based on the rules and regulations of that place. As I mentioned before, avoided costs, it's a calculation. It's not a negotiated price like you would see in a non-PERPA agreement.
Okay. And last question, you mentioned that the must-take agreements evolved a little bit over the course of this time period, correct?
Yes, I did.
But you knew from the get-go that Cherokee was not interested in operating under a must-take agreement, didn't you?
I knew that the power plant preferred at some point, I don't remember exactly, probably when I got their first or second counteroffer, that they preferred a dispatchable tolling agreement. I understood that. And again, it's my responsibility to, you know, I don't work for LS Power, I work for our customers. So what's best for their power plant may not necessarily be what's best for our customers. And at that time, again, as I mentioned before, we did offer them dispatchable tolling agreements on 2 separate occasions. Those costs, as I think you probably know, Mr. Pringle, that the February 21 offer based on the discovery request we got from ORS actually shows that the dispatchable tolling agreements that we offered in September of 20 and 20 were higher than the calculation in September of 18. So, but as the, you know, as we, you know, because this has gone on so long, the regulatory process in the Carolinas evolved. So each must take is a little bit different than the one before. And eventually we gave Cherokee what they asked. We gave them a dispatchable agreement. We gave them a tolling agreement. We gave them a 10-year term. And they still rejected those avoided costs. I apologize. They rejected those avoided costs, or they let them expire.
And as I started out with, that form of agreement that you offered to them came at least 2 years into the process of negotiation, right?
The dispatchable tolling agreement was first offered to Cherokee September 17th, 2020.
After they started this process in September of 2018, right?
Yes, that's correct. We got their first intent to sell in September of 18.
All right, that's all I have, Mr. Keene. Thank you very much, Mr. Chairman. Now, I'm done. Thank you.
All right, Office of Regulatory Staff.
Thank you, Mr. Chairman. Jenny Pittman for ORS. Just a few questions for Mr. Keene. Good morning, Mr. Keene.
Good morning.
What effect do these the 2 contract extensions have on Duke's customers? The contract extension from January 1st to April 30th, and then there's the next one through August 28th.
Yes. Do you mind if I just check my notes real quick? I made some
not
notes.
a problem.
Okay. Yeah, so, the two extensions have put us in kind of a challenging situation from a commercial perspective. The agreement that expired 12/31/20, we had a letter of credit of, to protect our customers of, I think the level was $1 million. Because we're paying rates right now that are, like I mentioned a few minutes ago, I guess they're 9 years old, something like that. They're well above our actual avoided costs, and I think all parties agree that there's going to be, at least depending on what the commission does, there's going to be some overpayment. So what we've tried to do when we got the first, we've calculated, it depends on how you look at it, and John, witness Freund can go into the exact calculation, but we've projected somewhere between this year alone that our overpayment could be maybe between $6 million and $9 million.
Okay, not an insignificant amount.
No.
How many qualifying facilities do the Duke entities have negotiated PPAs with?
Wow.
An estimate, I guess, if that's possible.
I apologize because I don't know how many solar ones we have, and I think we have a lot of solar. So I think Witness Snyder might be able to answer that better than me because I don't really know how many we have.
Okay,
Total.
that's all right. One last question for you. If this commission were to extend, each of the contracts Duke has with the qualifying facilities, like they've extended the contract in this proceeding, what impact would that have on Bears? I don't need an exact amount, but
That would be a really challenging calculation. Again, I'm not even sure how many we have, but it would be a significant number. If it's just this 100 this is less than 100 megawatts. It would depend on just when the rates were originally sent, originally calculated. But I don't know if we have that answer or not. But I don't have it.
But it could be a significant impact.
It would be a very big number.
Okay, thank you. No further questions.
Yeah.
All right, time for commissioner questions. Mr. Keene, I have a couple of questions for you, if you don't mind.
Of course.
That $6 million overpayment figure you just mentioned, is that in this case or is that overpayment for all QFs?
That is just this agreement and just for 2021.
All right. Well, I'm glad that ORS brought this up because I've heard it said often, and I somewhat agree, at the end of the day, it's all about the money. So it seems to me, just based off what I've heard so far, that Cherokee believes that Duke has in some way not given them what they are entitled to, if you will. You haven't operated in good faith, fair dealing, all the allegations that have been lodged against Duke. Are you under or aware, or do you understand any duty that Duke has to Cherokee to offer them what they think they deserve, or to give them what they think they deserve?
Well, Mr. Chairman, I mean, as I mentioned before, there's the rules and regulations as they relate to PURPA can change. So each time we get a request, as part of our process, I meet with our regulatory attorneys to help guide us through the process. We got a lot of QFs out there, so we try to deal with them on a non-discriminating basis. If someone comes to us, we try to treat them exactly the same we would everyone else. In this situation, when we receive the intent to sell, we give them our avoided costs based on the methodology of, at that time, what the rules require. And then as those rules change, through this process, there were 5 offers. Each time, maybe the rules are a little different. We could ask for a different term. Maybe the methodology changes a little bit. So we try to do that and follow that. But I mean, the key thing is we cannot pay more than our avoided costs. And we've offered our avoided costs to them 5 separate times, and they've rejected them all 5 times. And during this 3-year process, I don't know how many QF contracts we've signed, but we've signed a bunch. And you're right. And I think, Mr. Chairman, the other key thing to recognize is that they had a great opportunity. Their contract was expiring the end of 20. AEP had a significant capacity need at that time, like 2,000 megawatts. What a great opportunity. In your region, there's a 2,000 megawatt need, and you've got the opportunity, your contract's expiring exactly the same time, and you can just bid right into it. And if they had been, I was stunned that they were not competitive in that. We ended up executing 5 contracts, some PPAs, long-term agreements, 1,800 megawatts. We got great pricing, great counterparties. Those things were negotiated, executed, and they're up and running now. And Cherokee had a great opportunity to compete, but just like with the avoided costs, the market price, I guess, was just too low for them.
You know, it's sort of interesting when we have this discussion that the ratepayers are not mentioned more. It's the story is framed as Cherokee versus Duke, and I understand why, but those avoided cost rates are passed on directly to the ratepayers, are they not?
Mr. Chairman, I work for the customers. I do purchase power agreements for 3 of our big utilities. Just about every dime I spend in the PPA is paid by our customers, and that's who I work for. And when we go, if we go the non-PERPA process, we negotiate price very, very hard. We negotiate every word in the agreement to get the best PPA for our customers we can. In the non-PERPA basis, we follow the rules as required, and we just make sure that we don't violate those rules. And again, we pay avoided costs. We don't try to pay below avoided costs. We don't try to pay above avoided costs. We calculate them, and that's the number we're going to pay. And that's how we do our business.
Okay. Well, did you not give Cherokee the calculations or the information necessary for them to calculate your avoided costs back in 2018? Did you withhold information?
Well, let me try to answer that. And Witness Freund has been involved in this process from the beginning, and he's calculated avoided costs, and he will be better able to answer it in details. But I will tell you that we received a request from them May 6, 2019, and we provided a response in June, a month later. They didn't complain at that time that that wasn't enough. We didn't hear from them again for almost 10 months. In July of 20, they requested information again. The following month, we sent them a several-page letter answering what we thought were their questions. We also met with them on February 19th of 21 and had a conference call with them. The key thing is, and this is the hard part, Mr. Chairman, is how much information do you allow them to give? Do we want LS Power to full access to all of our files? So it's a challenge to figure out how much should be, even our IRP, if you've ever looked at those, they're just filled with information. But I think the question is, how much is enough? And they haven't been, I would tell you they're not satisfied with the amount of information we provided, but I think Witness Freund can provide a lot more detail, specific detail on what we've actually provided.
Mm-hmm. Let me ask you this. You seem to be very knowledgeable about this area. Do you think it's possible that the avoided cost rate that you offer could be too low for Cherokee to operate its business?
Mr. Chairman, that's a really good question. And I am very involved in the marketplace. I know a lot. I know I'm familiar with a number of QF contracts with technology like this. I'm aware of some that are operating now. I'm aware that some aren't operating more. I have met with some folks that own these power plants, and I've come to the conclusion, based on my research, that this power plant and this technology should be operating at the avoided costs we have provided. The avoided costs we provided, Mr. Chairman, are not out of line at all with the 1,800 megawatts of agreements we recently signed in a non-PERP agreement. So in my opinion, this power plant should be able to operate our avoided costs. That's just my opinion, though.
All right. Thank you very much, sir. Questions? Commissioner Powers.
Mr. King, thank you for your testimony. Thank you for your timeline. been studying it, and it's very helpful. There's such a difference or wide range between the two parties in this case. Has there been any consideration about, rather than coming to one number or the other on an immediate basis, some sort of step down that would make it where Cherokee can operate? Is there a number in between, or a period of time where the number could decrease?
I think again, I mean, we can't pay them more than our avoided costs, and we don't try, we try to pay them at our avoided costs. I think the most appropriate thing is the 210-21 offer, where that's the most recent offer. The rates are most current. It's a pretty strong offer. I think that's the appropriate thing. I really don't know, and that's been kind of the challenge, Commissioner, is that Ellis Power seems to think that we're, not negotiating good faith because we won't pay above our avoided costs. Well, I can't pay above our avoided costs. So it's getting a resolution been a challenge. Like I said, I've probably done during this 3 years, maybe 25 PPAs during this time frame. This one just keeps going on and on and on.
Well, with this PPA, I think your question was, technically it's over, but we've extended it. You're paying above your avoided costs at this time, are you not?
We are. I mean, yeah, that's true, Commissioner. I apologize. I mean, if the commission orders us to pay above avoided costs, we will, of course. And we are doing that right now. And our customers are at risk. They are at risk to that overpayment because we do not have any commercial protections at this time. We have sent the commission order. The key thing on your commission order on April 28, 21 that was important to us, I think it was the last sentence of the order. It said Cherokee should bear the economic risk of any possible overpayment from any extension of the 2012 PPA. Unfortunately, like I mentioned, the current agreement only has $1 million worth of letter credit. On one day after the April 28th offer, we sent a letter to Ellis Power requesting additional security. 1 week later, they refused that in a letter to us. We sent them a notice of deficiency letter on May 24th with a June 1st expiration date to send us additional. That expired. We sent them a notice of default letter on June 15th. Finally, we received an email from them on June 25th. We had a conference call with them that same day. We sent them a new letter to hopefully cure the event of default on July 6th. And at this stage of the game, we're hopeful that they will meet the next deadline and get us the LC we need to protect our customers.
What would you ask this commission to do to not just protect your customers, but to keep Cherokee in business?
I think again, Commissioner, I think the 210-21 offer, which is consistent with our methodology and our processes we've followed all along, which is to, use the most current avoided costs we can so that our customers are paying the avoided cost and not an avoided cost that's out of date. We think that makes the most sense. It's a dispatchable tolling agreement, which we keep hearing about, so important to them. And it's a 10-year transaction. And I think that should be the variable costs in that agreement, or the variable costs I believe they requested in all of their, I think the 210-21 offer is the way to go, sir.
Thank you very much. That's all I have, Mr. Chairman.
Mr. Keene, if I'm understanding you correctly, I'm concerned. I'm greatly concerned. I'll just say that, because it sounds like to me you're being very polite, and I applaud you for that. But what you're really saying is that the decision the commission made to extend this contract has put ratepayers at risk of overpaying for power, and Cherokee has not shown that they can repay that overpayment. Is that not what you're saying?
I'm saying that our customers are at risk, that we don't have the proper commercial protections now. We do have a key deadline that I think Cherokee has agreed to, I hope. And that's August 10th. We're supposed to get additional security. And then we're supposed to get an additional amount on September 10th. That was in our last letter. So we're hopeful to get that, but we are in a position that normally we wouldn't be in.
Right. Well, I'm not talking about what you think you're going to get. I'm talking about today. Today is your testimony that the ratepayers have paid $5 to $6 million over your avoided costs, right?
Yes, Mr. Chairman, I think this would be a good topic maybe to follow up with witness Freund. He's the one that's done all the projections, and we have projections like through August 28th, which is when your order ends.
Mm-hmm.
We have projections, I think, through the end of the year. There's a couple of different ways you can look at it. You can look at it assuming there is no PPA at all, or you could assume that the PPA continues at the 210-21. So there's a lot of different ways to look at it, but the range of numbers we're talking about are accurate.
Okay, that's fine. I'm not going to hold you to it to the closest decimal point. I'm just trying to get a general understanding. And I heard you say that you believe the overpayment is about $5 or $6 million to date, right?
I think that's projected to August 28th. But again, I think witness Freund would be able to give you a lot better idea of exact cost. But yes, it is I think by August 28th, we're assuming somewhere between maybe 6 and 9 million. But again, witness Freund would be better to get the exact numbers to you.
Okay, I'll ask him too.
We've looked at it several different ways, so I'm not sure I got all the numbers straight. So
understood. We'll definitely make sure to ask him that question too. And then also understood you to testify that. I'm sorry. Hello,
Mr. Chairman. This is Jack Pringle on behalf of Cherokee.
Yes, sir.
I don't want to interrupt, and I know where we are in the proceeding, but I just wanted to make a marker here that based upon this conversation, I'm going to ask for the opportunity to do additional cross-examination because of the issue that was raised that's not contained in testimony and that involves these numbers and these negotiations. You may continue, and I didn't mean to interrupt what's going on, but I just wanted to say this now. For the chairman's benefit.
All right, thank you, sir. So, Mr. Keene, you also testified that there's a $1 million letter of credit offered by Cherokee, right?
that was part of the 2012 RFP
Okay.
that we signed a while back.
Okay. And your testimony is also that you haven't received any additional letters of credit or guarantees to this point.
We have not.
So let's talk about worst case scenarios. If you don't get any additional letters of credit, what is the risk to the ratepayer? Is it possible that Cherokee would not be able to repay the overpayment if we adopt Duke's position or orders Duke's position?
Well, I mean, the thing you're trying to protect against, and I don't know that you said worst case scenario, Mr. Chairman. The thing you're most worried about is if they were to walk away from the facility. That might be the worst case scenario. I don't think that's likely to happen. I don't think that's likely to happen.
Okay. Well, what would happen if they walked away from the facility?
Someone else, I think we would probably be at risk to the full overpayment.
Okay. I got you. All right. Any other questions? I see Vice Chair Belzer.
Thank you, Mr. Chairman. Good morning, Mr. Keene.
Good morning, Commissioner.
Mr. Keene, I want to go back to your October 5th letter responding.
Okay.
I think it's attachment 3 in your direct exhibit number 2.
Okay, let me just get there real quick. Yes, I'm at that. Yes.
Okay. And you receive requests from these facilities, And in this letter, you indicate in the second line, you characterize, and the phrase is referencing Cherokee's September 17th letter, which purports to establish a legally enforceable obligation, or LEO. And then later in that paragraph, you state, however, DEC does not agree that the September 17th letter or the accompanying notice of commitment form referenced herein establish a legally enforceable obligation, or LEO, under PURPA. What would Cherokee have to have provided to Duke to establish a LEO in Duke's opinion?
Well, I think under a LEO, you need to have a binding obligation. It has to be something that both the counterparties can count on. So it would have to have been some type of an executed document would make a lot of sense. In other words, a letter agreement that both parties signed establishing it. The one thing we try to protect against, and this is kind of the situation I run into, is if they make a legal enforceable obligation, our utility planners need to be able to count on it. And that's kind of a key role. And so if they just say we're going to give it to you, or we're going to obligate it to you, and then they offer to do an RFP like they did here, or they offer it to another utility, that's not really a binding obligation.
Let's just talk about the September letter. Where was that deficient? Because the Duke letter came, 3 months later in December. So,
Right.
But PURPA does allow, it can be an oral commitment that could establish a LEO. Is that not correct?
I don't know if that's true or not. I've never heard that, but I mean, Witness Bowman, who's coming on a little bit later on, she'll be able to answer that question better than I can. I will tell you that what they could have done, I'll answer your question if I could, is when we sent them the avoided costs, they could have agreed to those. They could have said, because and I mentioned the process we follow. So the first thing that happens is we get a communication from the qualifying facility, which is what we got in September. Then, like I mentioned, we get a team together to make sure that we're following the right processes depending on what state we're working in and what the current rules and regulations are. We send them the avoided costs, and all they had to do was to accept those avoided costs. Either we would have taken an email on that situation like we do with other QFs, or some type of thing saying we agree to these avoided costs. And once they do that, then we would go to the next step, which is to negotiate and finalize a purchase power agreement once they agree to the avoided costs. And that's why you'll see in our letters, what we try to do with these is to let them know that the avoided costs are valid for 60 days. And if you don't select them during that 60 days, then they're kind of, they're stale, and the process would have to necessarily start over so that we're always at least trying to get to the most current avoided cost. But Witness Bowman can talk a lot more about the rules and regulations under PURPA and the legal enforceable obligation.
Well, you've mentioned a couple of times that the rules and regulations regarding PURPA can change, and you just stated current rules and regulations. Recently, last year, FERC issued an order, and then a rehearing order. But prior to that, when is the last time that the FERC's rules and regulations changed regarding PURPA?
Well, I think it's the way the rules and regulations are implemented by South Carolina. But I think, again, I'm the commercial negotiating guy, so the folks that kind of manage the rules and regulations, keep up to it, would be, I think either Witness Bowman or Witness Snyder would be better to answer those types of when the rules change.
Okay, but Mr. King, you've used that phraseology a few times in your testimony. That's why I'm asking. So you don't know the last time that they've changed. Is that correct? Even though you've referenced it.
I think the last significant change in South Carolina was probably, in my opinion, I think it was Act 62 was the last big change I saw.
Okay, but what about, you don't follow the FERC rules and regs?
I do not.
Okay,
I'm provided just the regulatory, the attorneys, since I do transactions in multiple states, it's a challenge, for me to keep up with all the rules and regulations in the different states. So the first step in our process is to meet with the folks that do keep up with that. And then they give us, I would say, the guidelines we need to follow for that specific transaction.
and that's internal in Duke.
Yes, ma'am.
Okay. In South Carolina, does Duke have any other large QFs operating as dispatchable facilities?
I am not aware of any large dispatchable QFs operate in South Carolina. I'm just thinking for a minute. No, I don't think, no. I'm not aware of any.
Does Duke have any large QFs in South Carolina as large as this Cherokee plant? This is 86 megawatts under the last contract.
I don't know what size. I'm not really involved in the solar side of the business very much, so I can't answer that as it relates to solar. But I think it is the largest non-solar one that I'm aware of.
And
I'm not sure if we have any solar plants bigger than that or not.
Okay. And you've mentioned the competitive procurement that Cherokee did not have their bid or did not participate in. Is that correct?
They did participate in it. They did submit a proposal.
Okay, but it wasn't competitive. Is that correct? Their bid?
No, it was not.
Okay. And how much was the capacity that Duke was trying to?
We were looking for about 2,000 megawatts total. We ended up receiving 20 proposals from 9 different suppliers. We executed 5 agreements for about 1,800 megawatts. All of those agreements were both PPA and tolling agreements. All of those were existing generation in the Carolinas. Those agreements have all been executed, and all that capacity energy is now being delivered to our DEP customers. And I felt like we got some great pricing and great counterparties, and it was a very successful RFP. We've actually extended a couple of those agreements now because of how good they are. It's unfortunate, but Cherokee, they just missed a great opportunity because their contract was expiring at the same time as one of the Duke utilities needed a significant amount of capacity. Going out for an RFP for 2,000 megawatts, that doesn't happen very often. That's a lot of megawatts. And unfortunately, they were the least competitive of all of our proposals and had the highest bid. And they were actually 3 times higher than the lowest bid.
And Mr. Keene, was that proposal conducted under Duke's CPRE program?
No, ma'am. The CPRE was a renewable energy. These were firm dispatchable natural gas resources, existing power plants.
It was all firm and dispatchable. Okay.
Yes, Commissioner.
Okay. Thank you for that.
You're welcome.
Let me see. I think that's all I have, Mr. Keene. Thank you for your testimony today and for answering my questions.
Commissioner Caston.
Thank you, and still morning. Good morning.
Good morning.
Chairman Williams is asking, touched on these, and I think you said Mr. Poon would be better to ask the question relative to aborted cost or I guess request on that. But I did want to ask, because that's still kind of fuzzy to me, if there were specifics. Are you aware, or do you know, if Cherokee requested any specific aborted cost information from the Duke companies?
Yes. We received a letter from them in May of 2019 when they requested information. We responded with our response letter in June of 19. At that time, we didn't hear back from them almost 10 months. And then we received another response and another letter requesting information from both utilities. I think so. We got two letters, one for DEP and one for DEC, if I remember correctly. That was in July of 20. In August of 20, we sent them a 3 or 4 page letter, and we thought we had answered their questions then. As part of this process, in February of 21, we also had a conference call with them. Witness Freund would be a lot better witness on exactly what information we provided him so far, and I think he could probably provide context on what the typical is typical for the industry and typical for the Carolinas. The challenge with the information request is just how much access and how much data do you want Ellis Power to have on our systems? And I think Witness Freund can answer that a lot better than I can.
I understand, and I'll make the point to follow up with them. Thank you.
Mhm.
And I know you've addressed this, but I just kind of want to ask it
Sure.
again, point blank. Cherokee claims Duke discriminated against them. Did Duke treat or negotiate with Cherokee differently than any other QF that they negotiated with?
I would say that we negotiated in good faith through the whole process. I would say, you know, I'll give you an example. Under the rules of South Carolina, we were not required to offer them a 10-year deal at the time we did, because they are not a small power producer. They're above 80 megawatts, but we did that anyways. I think if anything, we've treated them in good faith and maybe a little bit, maybe a little bit more than we should have. But I think we've treated them fairly and gave them some very good offers. And I don't understand why they weren't competitive in the RFP, and I don't understand why these avoided costs don't work for them.
Well, you may have answered the question, but I guess to be a little more specific.
Sure.
The Duke companies treat any of their other negotiated or negotiations with other QFs differently in Cherokee, better than Cherokee, or in any?
No, we did. No, we did not treat other QFs better than Cherokee.
Is there some requirement, proper or otherwise, that I guess requires Duke, or is Duke's responsibility to keep the Cherokee plant operating?
I'm not aware of any, no. Commissioner, as I mentioned before, as part of this process to prepare for this and to try to really, I've been in this business a long time, and I can't understand why this has been going on for so long and why we're having such a challenge here. But I've done some research, and I think power plants of this technology, I don't think they're obsolete. I think they can operate at the numbers we provide them. I can tell you that based on the RFP that we've went through, I know what other power plants are being paid. So I believe that the numbers they're saying, you should be able to operate a power plant like this on those numbers. But that's really for Ellis Power to decide, I guess.
Understand. Should the negotiations not work out, or the Cherokee go away? Does Duke have?
That would be a question. That would be a question to answer them. I think that, in my personal opinion, I think the February 10th, 21 offer, and this is based on everything else I'm seeing in the market, what other power plants are being paid, what we're negotiating agreements for now, I do believe that they should be able to operate that power plant at the February 10th, 21 levels. That's their decision. I think it's a pretty good number.
I understand. Let me finish the question, and then let's see if it's the same answer.
Oh, sorry about that.
That's
I
okay.
apologize.
if whatever happens, if it happens such that the Duke companies no longer purchase power from Cherokee for whatever reason, or the Cherokee plant goes away for whatever reason, does Duke have the appropriate generation backup plans, portfolio, or whatever to replace that?
Yes.
Good, thank you. Finally, and I think you said this would be a question for someone else. And, I must say, when Chairman Williams brought up the concern relative to the line of credit and where we are to date, and I think ORS addressed that too. I too have a concern about that, even going back to, and perhaps, well, in the earlier request for extensions, now let me just withdraw that, because it wouldn't be fair to ask when you wouldn't know. That's a matter to just be taken up later. I have no further questions. Thank you, Mr. King.
Thank you, Commissioner.
Mr. Chairman.
Commissioner Irvin.
Thanks, sir. Mr. King, are the rates that you offered in February of 2021 rates that you can tell us what the offer was at that time?
Sure, let me pull it up. I think it's, I thought it was in my, yeah, it's Exhibit 3, I believe. Exhibit 3 to my testimony. It's a term sheet there dated February 10th, 2021.
Yes, sir.
That's the offer we provided it then.
Okay, is that a confidential filing?
I think the area highlighted in, well, it's like an orange yellow is confidential. I believe, I don't know. I think it is.
Because I've found some publicly available information on South Carolina's avoided cost rates. And so I'm just wondering, Mr. Chairman, is that particular exhibit marked confidential, or am I allowed to ask you specifically what was offered?
It's confidential.
All right, sir. Well, then I want to ask that question. Is it fair to say, though, that, or do you know whether your avoided cost rates are close in line with Dominion Energy's avoided cost rates in South Carolina?
I don't know the answer to that. And I'm, witness for him does calculate our avoided cost, but I'm not sure if he's familiar with that either. I'm not sure who would have that answer.
All right, thank you, sir. I have no further questions.
Thank you, Commissioner.
Commissioner Thomas.
Thank you, Mr. Chairman, and thank you, Mr. Keene. I'm thinking back to the September letters.
Okay.
My understanding is that Cherokee sent one to DEC, and about a week later they sent another one to DEP. And I'm thinking that they pretty much offered to sell all of their capacity to each company in each of those letters. Is that correct?
It's close. We received the first communication when I say we, DEC received the first communication September 18th, 2018. And we got, the next one we received was for DEP, and that was 12/12/18.
Okay. So I guess what I'm trying to figure out is that if it is a Leo, and I understand that the Duke companies don't believe that it is, but if it is a legally enforceable obligation, then I guess it's just enforceable by the Cherokee side of the equation and not the Duke side of the equation. Is that correct?
Well, I can talk high level. I think witness Bowman can answer detailed questions about this. But again, like I mentioned a little bit ago, I think just there had to have been some type of obligation between the parties that where there was an agreement that an obligation had been established. Our contention is that ALEA wasn't established. There was no binding obligation on Cherokee that our utilities could count on that power plant. And that is somewhat consistent with the facts where they offered it 100% of the output they offered to DEC. A week later, literally a week later, they bid it into the RFP. And then a month or so after that, they obligated to DEP. So we didn't believe ALEA was established, but we did proceed and calculate our avoided costs based on that, the timing of those correspondences. So they got the avoided costs that were valid at that time.
Okay, I guess the issue that I'm trying to think through is that how is it possible for them to offer all of their capacity to two different organizations and expect to be able to fulfill that offer to both companies? I can't really get my head around that, and was just hoping that perhaps somebody could help me with that.
We have the same question.
Okay, well, thank you. That is all I had.
Any more commissioner questions? All right. Give me one moment. All right. There are no more questions from commissioners. Attorney Pringle, I understand you have recross, but before you get started with that, we're going to take our
I'm sorry. It's additional cross.
Additional cross.
Yeah. I'm sorry to interrupt you. Yeah, based specifically on commissioner questions. But yeah, I'm sorry. I didn't mean to interrupt you.
That's fine. We're all working here together. How long do you think it will last?
I don't think it will be very long. Perhaps 10 minutes, maybe less.
Well, you are between your additional cross is the only thing left before lunch. So I just want to. Oh, and then we also have redirect. So you know what? Let's do this. Let's come back at.
Sorry, Mr. Chairman. If it's helpful, my redirect will be very brief. I estimate like maybe 5 minutes.
Okay, well, let's try to knock this out. Finish this witness before we take lunch. Attorney Pringle.
Okay, Mr. Keene, good afternoon again. You fielded some questions from several commissioners about risks to customers associated with security and the like, did you not?
I did answer some questions on that topic from the commissioners. Yes, sir.
Okay. Can you point me to any information in your direct testimony where you quantified any overpayment that might take place with respect to Cherokee's operation under the extension of the PPA?
I don't believe there's anything in there in my direct testimony, subject to check, but I don't recall that.
Okay. So indeed, there is not any information about the amount of overpayment or the effect of overpayment or the discussions that you described between Cherokee and Duke with respect to appropriate security, is there?
I don't believe there was anything in my direct testimony that discussed that issue, no.
Okay. Indeed, and as a result of that, Cherokee was not in the position to provide rebuttal testimony or otherwise answer those allegations, respond to those numbers, provide its own characterization and discussion of what happened, was it?
Can you break that down? There's a lot to that.
Okay, all right. You mentioned, you threw out numbers like
Right.
6 and 7 million and others. That number was not in your direct testimony, correct?
That's correct.
And so as a result, Cherokee was not in a position to challenge that number or respond to it, was it?
Correct.
Okay. You went on to describe some correspondence that Duke sent following the commission's extension of the PPA. Remember that conversation?
That's when I talked about the different letters going back and forth about the overpayment issue?
Well, specifically about Duke Energy Carolina seeking additional credit. Do you recall that conversation?
Yes, I do.
Were you the author of any correspondence that was sent to Cherokee on that topic?
I was involved in the letters. I can't remember if I signed them or someone else did, but I was involved in drafting those letters.
Did Mr. Johnson sign the letter on behalf of Duke?
That's a possibility, yes.
Mr. Chairman.
Okay.
Apologies for interrupting. This is not so much an objection, but if it's helpful, I just wanted to say that the Duke companies will not object. Mr. Pringle, if Mr. Pringle wants to question his own witnesses on this topic, Mr. Keene was simply responding to a commissioner question. He wasn't trying to improperly introduce any new direct testimony.
Noted. Thank you.
In response, I would only say that through his testimony, Mr. Keene has now put numbers into the record in terms of potential customer effect, potential effects of the extension of the PPA, and it is, clearly something that needs to be explored, and that's why I'm exploring it with Mr. Keene. Mr. Keene.
Sure.
Are you aware that correspondence was designated by Duke as proprietary and confidential?
I don't recall that, no.
Okay. I'll just say this to Duke Counsel. I'm getting ready to show this document because Mr. Keene has raised it, and I want to consult about the proprietary and confidential nature of it.
What document do you have to show?
I will identify the document.
Yes, thank you.
Yes. This is a letter from on April 29th, 2021 to Carolyn Murph of Cherokee from David Johnson that took place right after the commission's extension of the PPA by order 2021-294.
Mr. Pringle, I don't know that we object to that, but I will say that I think that Mr. Keene may have been referring to a more recent letter between the parties that was sent in July.
In response to that, I'd say he mentioned specifically that following the commission's extension that there was an initial letter and then a notice of default and some additional correspondence. The letter I'm referring to was the first salvo in this.
Okay, we have no objection showing the letter.
Okay, let me show you this document. You mentioned that you were aware that this letter took place. Is that correct, Mr. Keene?
Yes,
And do you see at the bottom here where Duke asked Cherokee for $8,700,000?
we asked for a letter of credit in that amount, and I think the current letter of credit was 1 million. So I think that might have been
Okay.
the total we were asking for.
Okay.
Attorney
And it
Pringle, could
says
you
which
please,
cover-
Attorney Pringle, please, make that document bigger for us, please. Zoom in there.
Okay.
Or expand the document.
Let's see. Yes. Let me see the best way that I can. Oh yeah. All right. Well, that's a bit big. How's that? Is that bigger? How's that, Mr. Chairman?
That's good. Thank you.
Okay. Let me return your attention to that and get you to read what's after the bullet.
Issued in the amount of $8,700,000, which covers the potential overcharge.
Does the letter explain in any place how that potential overcharge was calculated or what it was based on?
No, it does not.
Okay, so just like the avoided costs that that Duke provided with respect to its October offer, Cherokee had to accept on faith that that number was correct, without any basis, without any calculation.
I suspect that if you had asked for that, we could have, and I think later on in the process, we did provide more details as we work through this process with you. But if you guys had requested additional information for that specific issue, we would have provided it.
Okay, there's no basis for that in the record of this case, is there, other than what you've just talked about?
Basis for which, I'm sorry?
That number.
No, there is no basis for that number in this case, no.
Okay.
That was calculated on or about April 28th, or, late April 21, that was calculated.
And in fact, Cherokee has no way to evaluate whether that is a real number, does it?
Not based on that letter, no.
Okay. And the parties, as you mentioned, have been negotiating this issue. Is that correct?
I would say that we hope to have reached a resolution, and we'll know, I think, when the key dates come up. I think the next milestone is August 10th.
Okay. So based on this discussion, this is not even a live issue before this commission, is it?
Again, I was just responding to the questions of the commissioners, sir. That's all I was doing.
Okay, and you were responding with very large numbers for the proposition that it had very large potential negative effect on customers, didn't you?
Yes, and it does.
Based on what?
Based on our analysis.
None of which is in your testimony.
None of which is in my testimony.
And none of which Cherokee would have had an opportunity to respond to.
It was not in my testimony.
And answer my question, and Cherokee did not have a chance to respond as a result, correct?
That's correct.
Okay. And isn't it true that the offers that Cherokee was making to you in response to October the year 2018 PPA offer were lower than Cherokee's current rates that are being paid by Duke.
Please repeat that.
When Cherokee provided a counteroffer to Duke's must-take PPA in October, when Cherokee responded in December and in subsequent conversations with you, did it not offer avoided cost rates that were lower than its current rates that Duke pays to it?
I don't believe Cherokee ever offered us avoided cost rates.
That's not what I asked you.
I think it is.
No, I asked you whether or not what they offered to you during this negotiation process was lower than what Duke is paying Cherokee right now.
Mr. Keene, before you answer that question, I just want to remind the lawyers and the witnesses that we need to maintain professional conduct. No need for any back and forth. The lawyers ask the questions, the witnesses answer the questions. Beyond that, anything else is inappropriate. Please proceed.
I apologize, Mr. Chairman.
Do you want me to repeat the question?
Please, Attorney Pringle, repeat the question.
Okay. Cherokee provided Duke Energy Carolinas with several offers of its own, did it not?
Yes, it did.
Those offers, each of them were lower than what Duke is paying Cherokee right now under the PPA, right?
That's correct.
Okay. And in fact, in the 2020 time frame where there were some oral offers that were exchanged, roughly in the September 2020 time frame, the parties were only about $1 million apart, weren't they?
I don't recall the differences at that time. How big the difference was.
Does that number sound accurate?
It could be that close.
Okay. And based upon
Chairman Williams,
Commissioner Williams.
does Mr. Pringle still need the item that was on the screen?
Attorney Pringle, do you mind
Probably not.
unsharing your screen?
Yes.
Thank you, sir.
It's unshared. Based upon that, and again, not knowing exactly how Cherokee could respond to these numbers that you've mentioned, how is it possible that these overpayments that you've mentioned have been published could possibly be as high as you claim?
Well, I would say that when you that question on how these calculations were made would be better suited if you ask witness Freund. He did the actual calculations and projections as it relates to the overpayment. And as I mentioned, when I answered the commissioner's questions, we looked at it several different ways. So, and in later correspondences, I know you've talked about the April 29th correspondence. In later correspondences, we did provide some detail. Cherokee provided some detail, and based on that response, to demonstrate our good faith and stuff, we did lower the requirements for the LC, and we hope to get those increased credit amounts in August and September like we've requested. But the actual calculations, projections would be better discussed with witness Freund.
Okay, and so the parties are negotiating that, right?
I'm hoping they're over. You know, we asked for LC and we didn't get it, so we're hoping we got our fingers crossed for August 10th.
But
I'll let you know on August
and,
10th if we get.
let me, and maybe this gets to this discussion we've having over and over again, but my question was, the parties are negotiating, right?
I am hoping that the negotiations are over, because I think the parties have agreed to a plan, but I don't know that, and I won't know that until August 10th.
Okay, let me ask it this way, Mr. Keene. Is it true that either the parties are negotiating or they have negotiated a resolution to this issue?
Well, all I can do is explain to you what the situation is, and you can decide that. I think the parties have agreed to a plan to resolve this issue, and the key milestone for that resolution is an increase in letter of credit on August 10th. So if we get that, then I think we've reached a resolution, or a beginning of a resolution, yes.
Okay, and then as a result, all of that testimony you gave about potential customer harm or customer costs is purely speculative, right?
No, I wouldn't say that. I wouldn't say it was purely speculative. It's based on reasonable numbers and reasonable risk. A deadline to get the credit. I mean, the May 6th letter, Cherokee refused to even provide letter of credit. Each letter, they said we didn't have the rights to ask for another letter of credit. So I'm hoping it's resolved. We've worked hard to resolve it. There's a lot of correspondence and work to get this resolved, and I expect and hope that we will get increased security in August and September, and then this issue will be hopefully a moot point.
And in saying that Cherokee refused to do something, that's your characterization of the negotiations, correct?
Well, I think in the May 6th letter that we were sent, if you read it, I think they say right in that letter that we refuse to do it and you don't have rights under the current PPA to do that. And I think specifically didn't like the sentence where Cherokee should bear the economic risk of any possible owner of any exit 2012 PPA. That's from the commission, and we thought that meant we should make sure that we're protected from this overpayment situation. And so we've tried to do that, and that's what we continually try to do, is to make sure that we have the proper protection in place, and that's all we've tried to do.
All right, last question. All of this discussion that this testimony you provided is your characterization of negotiations that are ongoing between the parties, correct?
Yes.
All right. Thank you, Mr. Chairman.
You're welcome. Redirect.
Thank you, Mr. Chairman. Mr. Keene, I'm going to keep this very brief so we can take our lunch break, but I do want to make sure, in the interest of transparency, that we close the loop on the conversation you just had with Mr. Pringle. So I am going to share with you a document very quickly. Okay. Mr. Keene, is this large enough for you to read?
Yes.
And is this the July 6th, 2021 letter that you were talking about just now with Mr. Pringle regarding the...
Yes, I think that's it.
Okay, and looking at these bullets right here, I think you talked about increasing the letter of credit by August 10th, and that will increase to a total of $3 million. Is that right?
That's correct. That's the August 10th deadline I was referring to, and there's a September 10th one right below.
And so, correct. So once the September 10th deadline passes, the letter of credit should increase to a total of $6 million. Is that right?
That's correct.
Thank you. Mr. Chairman, I'm not intending to submit this as an exhibit because I don't believe that Mr. Pringle submitted the previous letter as an exhibit, but if you would prefer that they be submitted as an exhibit, I can do that.
Your choice.
Okay, then I will not submit it as an exhibit. Bear with me one moment. Okay, Mr. Keene, turning back to the main substance of your direct testimony, I just have a few questions I wanted to tie up with you. So you've talked a lot today about the must-take form of the PPA that DEC and DEP provided to Cherokee originally in the fall of 2018. Do you agree with the characterization that those must-take form PPAs were intended for solar facilities?
No, the form of PPA that we use in South Carolina and that we sent to Cherokee is I would call it an all technology PPA. So it includes, I know it was referred to on Monday by some folks as a solar PPA, but that's a solar PPA. We use it for hydros. We use it for swine, poultry. We use that form of PPA for a lot of the QFs, if maybe all of them, as far as I know. But it's basically a PPA, and we can modify little pieces of it, take the solar piece out if it's not solar and things like that. But it's kind of I would call it sort of a template starting point for the PPA.
And to be clear, this is the template that you gave to Cherokee in the fall of 2018 is the same template that you would have given to any other type of QF generating facility, no matter the technology.
That's correct.
Okay, thank you. Turning now to the responses you sent to Cherokee when they requested information to support the company's avoided cost rates. You touched a couple of times on this in your response to commissioner questions, but after you sent your first response to Cherokee's request, which I believe was in June 2019, did Cherokee ever contact you to say that the response was insufficient?
No, that response, we got the request in May of that year, and we responded in June, and then I didn't hear from them for almost 10 months after that. And no, there was no, at that time, at least during that next 9-10 months or whatever, there was no additional conversation at all, and definitely nothing on requesting additional information.
Thank you. And in your opinion, did you personally act in good faith in your dealings with Cherokee?
Yes, I did.
And based on your experience negotiating PURPA PPAs with other large QFs, in addition to your knowledge and experience with the back and forth with Cherokee to negotiate the QF we're talking about today, do you believe that the companies acted in good faith in providing their avoided cost rates and the new PPA form?
I do.
No further questions, Mr. Chairman.
All right. Anything else for this witness? All right, sir, you are excused. It is 12:30. Did I hear someone? No? All right. It's 12:31. We are in recess until 1:15. Good afternoon, ladies and gentlemen. Welcome back to the Public Service Commission of South Carolina. We're here in docket number 2020-263E. I hope you enjoyed your lunch. Let's take roll. Present in the hearing room, we have Commissioners Powers, C. Williams, J. Williams, and Belzer, and Thomas. Joining us virtually, we have Commissioner Irvin and Commissioner Caston. At some point, we're going to get everyone back up on the bench at some point. All right. We finished with Witness Keene. Please call the next witness, Duke Counsel.
Thank you, Mr. Chairman. Brett Bracewell on behalf of the Duke Companies. Before I call Mr. Freund to the stand, if I could just briefly update the commission on the company's plan for the afternoon. We plan to call Mr. Freund to the stand, and then following that, Mr. Schneider. Ms. Bowman is also available today and is also available tomorrow morning. Mr. Schneider has an unavoidable personal family commitment tomorrow and would not be available to testify tomorrow, but he would be available on Monday afternoon. So I'm not sure the commission's plans late in the day. I know y'all have a 4 o'clock commission meeting. Is the expectation that we would continue after that meeting, or are we going to adjourn for the day prior to 4 o'clock?
We will continue after that meeting.
Okay, very good.
Thank you, sir.
Thank you. All right, the Duke Companies call Mr. John Freund to the stand.
Mr. Freund, if you would, take the witness stand and pause to be sworn in by the court reporter.
All right, sir, if you'll raise your right hand, please. Do you swear the testimony you're about to give in this case will be the truth, the whole truth, nothing but the truth?
I do. Very good. Good afternoon, Mr. Freund. Would you please state your full name for the commission?
Yes, my name is John Freund.
Thank you, sir. And by whom are you employed in what capacity?
I am currently employed by Duke Energy as a senior structuring analyst. Among other things, my responsibilities focus on avoided cost methodology, rate design, pricing, and support related to purchase power for large QFs, and developing economic analysis and methodology support for the company's avoided cost calculations.
Thank you, sir. And how long have you worked for Duke Energy?
I've worked in various aspects of rate design and other analytical roles at Duke Energy or its predecessor utility, Duke Power, since 1977.
All right. And Mr. Freund, did you cause to be pre-filed in this proceeding direct testimony consisting of 17 pages?
Yes.
And your initially filed direct testimony included certain information that was designated as confidential and filed under seal. Is that right?
Yes.
And then on July 23rd, last Friday, the company's refiled your direct testimony and unredacted all information in that testimony, which was specifically filed under seal on pages 13, 14, and 16. Is that right?
Yes.
Okay. And do you have any changes to your direct testimony as it was refiled with the commission last Friday?
Yes. On page 5, footnote 2, the word mitigation should be replaced with mediation. So the sentence should now read, as discussed by witness Keene, the rates provided by DEC to Cherokee in February 2021 represented DEC's effort in anticipation of the February 2021 mediation to reach agreement with Cherokee.
Do you have any other changes to your direct testimony?
No.
Thank you. And with that change, if I were to ask you the same questions today that appeared in your pre-filed testimony, would your answers be the same?
Yes.
Thank you, Mr. Chairman. At this time, I'd ask Mr. Freund's pre-filed direct testimony to be entered into the record as if it was given orally from the stand.
Mr. Freund's pre-filed direct testimony, the corrected version, will be entered into the record as if given orally from the stand.
Thank you, sir. And Mr. Freund did not have any exhibits, so no exhibits for this witness to be entered into the record. Mr. Freund, I'd now like to briefly walk you through a summary of your direct testimony so you could provide that to the commission. Starting on page 3, you provide an overview of the purpose of your direct testimony. Can you summarize that overview for the commission?
Yes. My testimony explains how the companies calculated the avoided cost rates that were provided to Cherokee on 5 different occasions during the 2018 through 2021 time period. I show that all of these rates were calculated in a manner that was consistent with the avoided cost methodology approved by the Commission and with the methodology used to calculate rates for other large QFs requesting to sell to the companies under PURPA at DEC's or DEP's avoided cost. I also address witness Strunk's rate recommendation and explain why his calculated rate is inappropriate and significantly exceeds DEC's avoided cost.
Thank you. Moving on to pages 5 through 11 of your testimony. In that next section, you describe how the companies calculated the avoided cost rates offered to Cherokee. Can you please describe that process for the commission?
Yes. The companies calculated avoided cost rates for Cherokee 5 times in October of 2018, January of 2019, June of 2020, and September 2020, and February 2021. My figure 1, included in my direct testimony, presents the key attributes of each of those rate proposals. As you'll see from the figure, 3 of the proposals were structured as must-take agreements, and 2 were structured as dispatchable tolling agreements. However, regardless of the structure, each rate was calculated using the company's standard process for large QFs, basing rates on then current inputs in the same manner that DEC and DEP calculated avoided cost rates for other large QFs. In other words, each time I calculated the rates for Cherokee, I used a consistent methodology like we do for all other large QFs to ensure we treated them in a non-discriminatory manner.
All right, and turning to page 9 of your testimony, you addressed the fact that the companies provided Cherokee dispatchable tolling agreements later in the negotiation process in September of 2020 and February of 2021. Does that mean that the earlier offered PPAs were not accurate and appropriate for the Cherokee facility?
No. While the structure of the rates differed, that does not impact the accuracy or appropriateness of any of the rates provided to Cherokee. In each instance, the avoided cost rates provided to Cherokee were calculated in a manner that was consistent with the company's standard and accepted methodology for developing avoided cost rates for large QFs by using the most current inputs and assumptions at the time.
Thank you. And then on pages 11 through 15, you address witness Strunk's avoided cost rate calculation. Can you briefly describe your understanding of witness Strunk's calculation?
Yes. Witness Strunk calculated a $110 per kW year payment to Cherokee, which he derived using the rates DEC provided to Cherokee on October 31, 2018.
And do you explain in your testimony the company's position on witness Strunk's calculation and whether you agree with that calculation?
No. For one thing, witness Strunk's calculation greatly oversimplified the determination of an avoided cost rate and are not consistent with the standard of accuracy used for calculating rates for DEC or DEP's other QFs. He did not have the benefit of running a production cost model and admits that his simplified calculation was intended to provide an order of magnitude estimate of avoided costs applicable to a dispatchable PPA for Cherokee. More importantly, however, witness Strunk made a number of unreasonable assumptions that resulted in his proposed rate both significantly exceeding DEC's avoided cost and lacking comparability with the dispatchable tolling price quotes made by DEC. First, he failed to recognize that DEC has and continues under the extended agreement to pay Cherokee a start fee each time the plant is dispatched. In addition to the extended agreement, the two dispatchable tolling PPA price quotes DEC made to Cherokee also assumed separate start pricing. The amount representing the payment to Cherokee for start costs must be subtracted from witness Strunk's $110 per kilowatt year estimate in order to provide an apples to apples comparison of that estimate to the extended contract pricing or the two DEC price quotes to Cherokee for new dispatchable tolling PPA, or a new dispatchable tolling PPA. In addition, witness Strunk incorrectly assumed avoided capacity costs for all years of a new PPA. The standard methodology for large QFs that the companies follow, which has been accepted by this commission, provides that capacity rates should only reflect avoided capacity costs for the years of the contract in which the utility has an avoidable capacity need. Witness Strunk's $110 per kW year amount included an avoidable capacity cost of $47 per kilowatt year. That's close to half of the $110 per kilowatt year, which he derived from the capacity pricing in the standard offer, Schedule PP in effect, and available to small QS, but not Cherokee, during the 2018 period. That version of Schedule PP reflected an avoidable capacity need in all years and was outdated at the time we calculated rates for Cherokee. In my direct testimony, I replaced his $47 a kilowatt year avoided capacity cost with $15 per kilowatt year, which I calculated using the inputs that we used for large QFs for avoided cost pricing in September of 2018.
All right, and can you please summarize your testimony on the overall impact of these flaws in the aggregate in witness Strunk's calculation?
Yes. Between the two adjustments I described, witness Strunk's $110 per kilowatt year would be reduced to $58 per kilowatt year. However, even with this adjusted rate, it would be inappropriate because, as already discussed, witness Bowman discussed, DEC does not agree with Cherokee having established a LEO in 2018, and therefore DEC also disagrees that Cherokee is entitled to now stale and less accurate 2018 vintage avoided costs.
Thank you. And to summarize your testimony, in your opinion, have the companies followed a reasonable and consistent methodology in calculating avoided cost rates for Cherokee over the 2018 to 2021 timeframe of negotiations?
Yes. All the rates provided by DEC and DEP to Cherokee during this time frame were consistent with the methodology approved by the Commission for calculating avoided cost rates for large QFs. In contrast, the rate proposed by Cherokee witness Strunk is flawed in a number of ways. It lacks the accuracy normally reflected in the calculation of avoided costs for QF pricing and is based on information that was out of date for the purpose of calculating avoided cost pricing for large QFs. His rate, as calculated, significantly exceeds DEC's avoided cost at any point during the negotiations.
Thank you, Mr. Freund. Mr. Chairman, Mr. Freund is now available for questions from the parties and the commission.
Thank you, sir. Cross-examination.
Thank you, Mr. Chairman. This is Bill DeGrandis. I will conduct a cross-examination of Mr. Freund. Good morning, good afternoon, Mr. Freund.
Afternoon.
Mr. Freund, let me first mention, if I mispronounce your name and call you Mr. Freud instead of Mr. Freund, please correct me.
All right.
Mr. Freund, you testified you're a senior structuring analyst for Duke Energy, correct?
That's correct.
And you were employed by the holding company, Duke Energy?
Yes,
And then you have responsibilities for both DEP and DEC with regard to PERP, is that right?
that's correct.
Okay. You mentioned a chart you developed at page 5 of your testimony. I'd like to turn to that chart now. It says page 5, labeled Figure 1. We have it up on the screen for everyone's convenience. And in reviewing the chart, Mr. Freund, it appears that of these 2.5 rate proposals that you've outlined here, 2 are from DEP, correct?
That's correct.
And then 3 are from DEC, is that correct?
Yes.
Okay. Now, in reviewing your chart for the September 2020 DEC proposal, there's a footnote 3 that says this proposal was conveyed during a telephone conversation between Mr. Hansen from Cherokee and Mr. Keene from Duke, right?
That's correct.
And do you know if this oral offer was ever provided in writing to Cherokee?
I'm not aware.
Okay. Now, you mentioned that, I mean, we're going to talk more about your calculations or your adjustments made to Mr. Strunk's analysis, Mr. Freund. But one thing that struck me in your summary, you said that Cherokee did not produce any production cost model. Let me ask you this. I know you compute the avoided cost rates for these offers. Do you actually see the package that goes out to the QF, or in this case, to Cherokee?
I can't remember if I saw the letter that went to Cherokee. I typically do not see the communication letters to the QFs.
Okay. Are you aware that the October 2018 proposal from DEC contained just a rate and a form contract? Are you aware of that?
Well, yes.
Yeah. So with just a rate and no backup, it's pretty hard to do a production cost model. Would you agree?
Well, the rates that we developed that went to Cherokee were developed using a production cost model.
But in what was received by Cherokee, there was no backup showing underlying assumptions, gas cost, anything. It was just the rate and the form contract. Is that correct? Or is that
Yes.
to your knowledge? To your knowledge, is that correct?
That's correct, but that's our normal procedure, is to send out the avoided cost pricing.
Now, focusing on the last 2 columns, the September 2020 and the February 2021 proposals, they were both for dispatchable tolling agreements, correct?
That's correct.
Okay. And the both of those same offers, the September 2020 and the February 2021, they used 2026 as the first year of capacity need, correct?
Yes.
Okay. I'd like to move from the chart, if I could, and turn to what's labeled as Cherokee cross-examination exhibit Freund number 1. Let's go to the first page of it. I'm sorry, we just had an excerpt of it. Okay. Mr. Freund, are you familiar with this order? It's been discussed at various times during this proceeding. I don't know if you've been sitting in and listening to the testimony, but does this appear to be the Duke, DEC, and DEP, I guess, avoided cost order issued by the commission in this 2019 docket and dated January 2nd, 2020? Does that look familiar?
It does.
Okay. I'd like to refer you to page 90, if we could. Great. Also, I want to refer you to here, Mr. Foyne, the commission, in fact, in that avoided cost proceeding concluded that DEC's identified first capacity need is in 2026, correct?
Mr. DeGrandis,
Yes,
could you enlarge the document on the screen, please?
sure.
Thank you.
And is Commissioner, is that what all I'm focusing on, and all I'm asking the witness about is the first capacity need at the bottom of page 90, identified as 2026.
That's much better.
You see
Please.
that? Thank you. And please, if you ever need any enlargement, I am usually the first one to say I need things enlarged, but thank you. So, Mr. Freund, now you recall that, correct?
Yes.
Okay. Thanks. Now, the orders, you're aware that Duke disputes whether a LEO was formed. We can exhibit. Mr. Chairman, this is from a commission order. I don't think I need to have it admitted as a hearing exhibit. It's I just wanted to use it as a cross-examination exhibit.
It's up to you whether to admit it or not, but you can ask for judicial notice.
Okay. We'll just ask for judicial notice then. Thank you.
Thank you.
Thank you. Okay. Now, Mr. Freund, you sound like you're aware that there's a dispute in this proceeding, but we can leave that exhibit now and just go back. Let's go back to Mr. Freund's.
Mr. DeGrandis, I think
one. There we go.
you control the exhibit, so you can take it down.
I actually have someone helping me, Your Honor.
Okay, thank you.
Sure. Mr. Freund, you're aware that there's a dispute in this proceeding as to whether Cherokee formed a legally enforceable obligation in fall of 2018, correct?
Yes.
Yeah. Now, you calculated the rates in all these four subsequent offers labeled in the next four columns, February 2019 thereafter. You calculated the rates that were in those?
Yes, I did.
Okay. And that was based on the current avoided costs at the time. Is that correct?
That's, well, the date it was calculated did refer to a relevant date. It's like data request was in December, and if you look further down the table, it says timing of gas cost assumptions. That corresponds to December as well, and so that's indicating a tie between the date of the inputs versus the date of the request. So in this case, we used December of 2018 inputs for calculating the avoided costs.
Thank you, Mr. Freund. Now, let's focus again on the last two offers, the September 2020 and the February 2021. Those were both for 10-year terms, correct?
That's correct.
Okay. Now, the February 2021 offer, you calculated those avoided cost rates that went into that offer?
Yes.
And the gas cost assumptions you used were as of August 2020, correct?
Yeah.
I was looking at your chart.
Yes.
Okay. Right. They weren't based on the date that Cherokee has said they formed a LEO. They weren't based on fall 2018, correct?
That's correct.
Okay. Now, I don't know how the process is, but someone asks you within Duke to calculate avoided cost rates for a QF as of a certain date. Is that right?
That's correct.
And when you were asked to help develop the avoided cost rates for the February 2021 offer, what time period were you asked to use?
Well, in this case, we were looking at the South Carolina Commission had ordered the company to introduce and periodically update a large QF tariff in South Carolina. And so we had a large QF tariff in place, and we used the inputs that were used for that most recent update of the large QF tariff. So we got away from this idea of updating avoided costs monthly, but rather started relying on the inputs that we use for roughly a quarterly update process for the large QF tariffs.
So, Mr. Freund, did you ask whoever asked you to do the avoided cost rates that eventually went into the February 2021 order? I'm sorry, February 2021 rate proposal. Did you ask, well, wait a minute, I think these are the guys that say they have a LEO as of fall 2018. Should I use fall 2018 based on what was known then, or should I use current? Did you happen to ask that question of whoever asked you to perform these avoided cost rates calculations?
The guidance I was given was to use the most recent inputs for the current tariff that was on file.
And no one raised with you, well, there is this issue out there that they claim there's a LEO as of fall 2018. No one raised that with you?
No.
Nor did you raise it, correct?
That's correct.
Thank you, Mr. Freud. Next, I want to turn to some of the calculations you made when you were kind of critiquing Mr. Strunk's calculated $110 per kW year payment. So I'm going to ask you some questions, Mr. Freud, that kind of go pages 11, 12, 13 or so of your testimony. But let me start off. You, in your summary, you noted that Mr. Strunk has proposed a $110 per kW year payment to Cherokee, correct?
That's correct.
And that's made up of a according to his calculations, a $63 per kW year avoided energy rate and a $47 per kW year avoided capacity rate. Is that right?
Yes.
Now, on page 12, and I want to make sure we're accurate here, page 12, lines 6 and 7, you say you're going to make some adjustments to Mr. Strunk's calculations, even if the commission were to assume that Cherokee established the LEO in September 2018, even if they did, that certain adjustments to the $110 rate must be made to fix certain inappropriate rate calculations. That's your testimony there at page 12, lines 6 through 7, correct?
Yes.
So my question's out. I understand you and Duke do not agree there's a LEO. And so that's a prerequisite to these questions. I understand that, but I just want to try to clarify some of the adjustments you're making to Mr. Strunk's calculations. All right? Now, in your adjustments to Mr. Strunk's rate, you assume a 10-year PPA for the years 2021 through 2030. Is that correct?
I assumed a 10-year term for one of the components that I adjusted. That was the capacity component.
Okay. And in the 10-year term, that would be, for that component, that would be January 2021 through the end of December 2030?
That's correct.
Okay. And this was you're assuming a dispatchable PPA, correct?
Yes.
Okay. Okay. Now, page 13, the first adjustment you made was you deducted the $20 kW year startup cost, correct?
That's correct.
And you reduced Mr. Strunk's $110 figure by reducing the startup cost because DEC is paid for startup costs separately under the PPA. Is that right?
Yes, that was under the current contract, the extended contract, and was also an assumption in the quotes that DEC made to Cherokee for a dispatchable tolling PPA.
So it's kind of like you want to avoid any double counting by subtracting because they're already getting paid for them, right?
That's right.
Okay. Now, but assuming a dispatchable tolling agreement structure, you don't dispute that startup costs should be paid for, correct?
It's traditional in these type of contracts or capacity type contracts. Dispatch capacity type contracts.
Right. Now, turning to page 14, we have your confidential version here. I'm sorry, we should have had your, the numbers have since been released. We'll hide them for the record. You can help me with that, Mr. Freund, to the extent we have a blackout here. Sorry, we have your previous confidential one. But on page 11, by using a 10-year term, you're capturing capacity for the years, according to your calculations, 2028 through 2030, correct?
It captures avoided capacity costs for those years.
Right. Now, you reduce Mr. Strunk's calculated rate further by $32 per kW year in order to account for years, I'm quoting from your testimony at page 14, when DEC projected it would have no avoidable capacity need, correct?
Could you repeat that question? I missed part of it.
Sure. Besides the $20 deduction you made, you also deducted, I'm looking now at this line 19, $30 kW year to account for the years of the contract in which DEC would have no avoidable capacity need, correct?
That's right. $32 per kW a year.
Right, $32 per kW a year. Now, okay, so you were eliminating the years when Mr. Strunk may have had years when capacity would be owed, but you eliminated those years and stuck with the 2028 to 2030 time period. But the $32 represents years when DEC had no avoidable capacity need in your calculations. Is that right?
Well, let me explain the $32 per kilowatt year, just to be sure everybody is clear on what that represents.
Okay.
So Witness Strunk had calculated the $47 per kilowatt year that he represented as the avoided capacity cost, where I calculated $15 per kilowatt year. So that $1 per kilowatt year represents the difference. And so that is the reduction that needs to be made to his $110 to remove the excess avoided capacity cost.
Is there anything else embedded in that $32 per kW year reduction other than reducing it for the capacity payments in the years when you view DEC didn't need the capacity? Is there anything else embedded in it?
No, that should be it.
Okay. So you reduced, just to recap, you took Mr. Strunk's $110 kW year, you reduced it for startup costs by deducting $20 per kW year, and then you reduced it another $32 to reflect 3 years of capacity, is correct?
Yes.
Yeah. So you end up with this $58 per kW year. This is on line 21 of page 14 that we're looking at there. So you end up at the $58 per kW amount, correct?
That's correct.
And that includes $47 for the energy per kW year energy rate and $47 energy rate, is that right?
Well, it's got the avoided energy cost, but then we subtracted the $20. I think of that as, is there a reason we can't start from the 110 and just subtract the 20 and then subtract the 32? That's been, I thought it did pretty good job of explaining that.
Yes, and that gets you to 58, doesn't it?
Yes.
Okay, so my question is, the 58 includes how much for capacity? Is that
I mean, this of course is intended to be an order of magnitude representation, but that conceptually would be the capacity rate. That's the fixed fee. So that's the amount we would pay every year over a 10-year term, regardless of how much we actually dispatch that plant. And that's
okay, but this is the
comparable
total
to,
rate, correct?
that's the total fixed component of what we pay, which is going to be
Right.
for the current contract. It's actually composed of two fixed components. One is they call it it's a capacity fee, and the other is fixed O&M fee. The fixed O&M fee escalates over time, but it's a fixed inflation factor. And then the capacity component is fixed at the same level for all years. But the sum of those two components is what I refer to as the contract capacity payment or charge. And that's what I'm representing with the $58 per kilowatt year. That's the fixed payment, total fixed payment, regardless of how that facility is dispatched.
Okay. Let's scroll up to line 11. And there we go. Focusing on, actually it changed a little bit. It's actually line 13 here. When you made your deductions, you note that this results in an avoided capacity cost rate of $15 per kW year, correct?
That's correct.
That's the capacity cost component of the fixed component, if you will.
That's right. The total fixed fee, or what I'd call the contract capacity price, is supported by two forms of value. One is the avoided capacity cost. It's based on the peaker method, and it's capturing the first year of avoidable capacity need and beyond. And the other component relates to the energy value that we expect to realize by dispatching the Cherokee project. But that's taking into consideration the benefits of displacing generation of other resources, but then it has to account for the cost of fuel and variable O&M payments that we make to Cherokee, and also the start payments.
Okay, so your adjusted avoided capacity rate of $15 per kW a year, that's assuming, just looking at the previous couple lines, a avoided capacity cost starting in 2028, correct?
That's right.
Okay, and so that's 3 years of capacity payments, I guess 2028 to 2030, correct?
Well, it's 3 years of avoided capacity cost because we actually spread that over the full 10 years, so they get paid something every year.
Right. But the capacity payments, if you will, were accruing for the years 2028 to 2030 when DEC needed the capacity, correct?
That's what they're capturing, is avoided capacity cost.
Understood. Thank you, Mr. Freund. Mr. Freund, now I'd like to show you what's labeled as Freund Cross-Examination Exhibit number 2. All I want to do is determine, for purposes of our discussion today, what impact there would be on that $15 per kW a year capacity rate if we started capacity in 2026. Recall that's what that commission order we just looked at, instead of 2028. So all I'd like you to do, now I would first caveat this, like Mr. Brushworth, your attorney, I also was a political science major. So I'm showing you what I think is the most simplified calculation around, because even I understand it from a simple math or arithmetic or algebra basis. But all I want to do is for the commission's review to show if you change just this one component of your adjustments to Mr. Strong's calculations and started capacity or gave a credit starting in 2026 instead of 2028. So we have 5 years of capacity instead of 3. All I want to do is simple math to figure out what that is, what the capacity payment would be. With the following caveat, I understand there's timing issues. I understand there's net present value, and I want to give you the opportunity to comment on that. Could we just do this one simple calculation, just simple math, that if we change the capacity from 2028 to 2026, so we have 3 years of capacity instead of 5. Now, I didn't learn this in political science class, but I think high school algebra. $15 is for 3 years, as we're finding for X for 5. We get 3X equals 75. So you get X equals $25 per kW a year. Is that just a very simplistic way to say if we added those 2 years, what impact that could have on the $15 per kW rate that you calculated?
Well, the calculation takes a consideration of the time value of money, so it gets into a more complicated calculation than what you're depicting here. We're hoping for, I guess. But I think when you relate to 2026, and that's then relating to these more recent dispatchable tolling PPA quotes, important to recognize that there have been changes in addition to just adding 2 additional years of avoidable capacity need. Between 2018 and 2020, our annualized cost of new CT capacity that we use for avoided capacity cost calculations has increased, and it's a significant increase. So when we use the more current representation of avoided capacity cost, rates that we calculate today are getting the benefit of both more years of avoidable need within that 10 years we're talking about, as well as an assumed higher annual cost of a combustion turbine, which just says the avoided capacity cost in each of those years is higher. So you really have to account for both of those impacts to get any fair comparison of the more current assumptions with the $15 a kilowatt year that I represented, as though we were looking at it from the 2018 timeframe.
Yeah. Well, Mr. Freund, the other thing is I'm going to point out there's a net present value component, but because we're having capacity start 2 years sooner, if we looked at net present value and adding 2 years and earlier years rather than later years, the net present value, just focusing on that, might tend to move the $25 per kW a year calculation up a little more. Wouldn't that be right?
Yes, yes. By having it sooner, it has greater value, present value. In fact, let's see, I think I have, if the commission would like to know what would go in the right-hand side of the equation that is representing 5 years of avoided capacity cost, when we calculated the February 21 DEC quote, that avoided capacity cost component was roughly $36 a kilowatt year.
Okay. Mr. Freund, for purposes of I took it down to the basics so a political science major like me and Mr. Bryceburg would understand. And I understand there's complications and there's a lot of other factors, but if we just took this straight calculation, that results in a $25 kW year payment, which is $10 higher than the $15 one you had, correct? Just focusing on without getting into these other factors. Is that right?
I'm just not following your calculation.
Okay. All we're trying to do is add 2 extra years of capacity and start in 2028 instead of 2026 and say, put the aside net present value and timing issues and just focus on if it was strictly an algebraic relationship, it's $15 for 3 years. That would turn out to be $25 if you added 5 years, other things being equal. And all I'm asking is, if that were the case, other things being equal, and we only focused on that simple math, that is a $10 more than the $15 calculation that you had in your testimony. That's all I'm asking.
I don't want to sound stubborn, but the $15 per kilowatt year was calculated using the present value type math. And the only way to get a comparable number for a 10-year term representing 5 years of avoidable capacity or avoided capacity cost is to run that calculation the same way. You could say, well, but use the same annual cost of a combustion turbine that was used in the 2018 calculation. But what does that tell us? That's not telling us the difference between avoided cost today of capacity versus what we would calculate in 2018. So I'm really struggling to help you with whatever it is you're trying to understand.
Well, again, Mr. White, and I don't want to, again, and oversimplify things. All I was trying to do was show just a simple math formulation of what would happen if you went and added 2 years and started the capacity in 2026 to 2028. Fully aware that there's a lot of different factors. You noted that net present value could, if you took that into account, could actually increase this amount. So I just figured that this would be just to show that this is a higher than capacity rate than you would determine if we added more capacity earlier years than starting in 2008. That's all I was trying to strive for.
Well, I can't do this calculation in my head. The best suggestion I can make is perhaps ask witness Strunk to make the calculation. I'm testifying.
Right. Mr. Freund, maybe there's another way to go at this. Let's turn now back to your testimony to pages 15 and 16. You make additional adjustments. In some cases, talking about assumptions underlying the February 2021 avoided cost rate proposal. And you make these other adjustments. I'm going to page 15. And now let's turn to page 16 of your testimony, where you come out and say, well, I came out with $56 per kW year. And that's a total. That includes avoided energy rate and the avoided capacity rate, correct?
It has both sources of value accounted for.
And could you break that down for us? What is the capacity rate included in the $56? What's the energy rate?
All right, it's rounding is what gets us here when we add the components together, but energy is roughly $21 per kilowatt year, and capacity is $36 per kilowatt year. Now, the actual result of the sum of those two is $56.48, which if you round down to 56, that means those two values I gave you won't add up quite rightly, but I hope that's close enough.
No, that sounds close enough, Mr. Freund. Let me make sure that I understand. So this $56 amount, did you say that $36 of the 56 per kW year relates to capacity? Is that correct?
Yes.
And then the remainder, $21, that's the avoided energy component. Is that right?
That would represent the energy value of dispatching Cherokee over the 10 years.
And then again, this includes, just go back to the previous page, you used a 2026 start year for the capacity. First year of capacity, you used 2026 in calculating the $56 amount. Is that correct?
That was the first year of avoided capacity cost.
Great. Thank you, Mr. Freund. Mr. Chairman, I have no further questions.
Office of Regulatory Staff.
Thank you, Mr. Chairman. No questions for this witness.
And thank you, ma'am. Commissioner questions.
I'm all in.
Commissioner Caston.
Good afternoon, Mr. Freund. Is it Frill?
It's Freund. It's kind of like Sigmund Freud, but you have to squeeze an N right before the D.
I was kind of concerned as Attorney DeGrandis was. I didn't want to make that Freudian slip either.
That's all right.
That said, I don't want to beat a dead horse on those numbers because that was kind of tough to follow. I think I understand what the question was. If you use 2026 into 2028, you're saying it's not a direct ratio. It's as simple as A is to B is X is to Y or whatever, correct?
The example that I was asked to help create was not a straightforward request to satisfy.
And if I understood you correctly, you were saying to use, say, 5 years instead of 3 years would simply require the same calculation methodology for the difference. Is that correct?
I would be using the same methodology for both, where if you can relate to the process of calculating the present value of for a 10-year period, in the first case where you have 3 years of avoided capacity cost in the last 3 years of that 10-year period, and then doing the same, but now we have avoided capacity cost in the last 5 years of the 10-year term. And then those costs are levelized over the 10-year period. But I had also explained that if you're relating to trying to compare 2018 avoided costs with the more current avoided capacity cost, the increase in avoided capacity costs that we see in the newer avoided cost estimates is both the result of having more years of avoided capacity cost in that 10-year period, but also the avoided capacity cost that we assume in each of those years is higher than what we were assuming in 2018. So the more current avoided capacity cost calculation that goes into the February 2021 quote is really getting the benefit of both an earlier first year of need and also a higher avoided capacity cost per kilowatt of capacity. And that's both of those components are key in understanding why we're paying a good bit more for capacity, or would pay a bit more for capacity today than we would have in 2018.
Okay, so in essence, what I think I'm hearing is that there are multiple variables and you can't modify one variable without considering the other variables that would also come into play. Is that correct?
That's right. That's correct. And I'm sorry to start talking before you stopped, but I think you were right on target. And I'm just making the assumption that there is an interest in understanding what we quoted today, or in the February 2021 price quote, how that should compare to a calculation using 2018 inputs that is done in a manner that is comparable. And that is with each of those results representing a contract price that we could use in a new contract. Now, in the case of 2018, I'm working with the rather simplistic calculation method, but I think it's meaningful in my mind to at least see that the two numbers, $58 per kilowatt year for the 2018 inputs versus $56 per kilowatt year using the more current inputs, they're about the same.
Okay, thank you. I think I followed most of that, but it kind of reminds me of going to calculus class right after lunch.
Oh,
Awful time. But thank you. No more questions, Chairman.
All right,
Mr. Chair.
Commissioner Urban.
Thank you. Mr. Fron, I have a few questions for you. I'm sure you're familiar with PURPA regulations, correct?
I'm familiar.
And you were aware that there was an important final rule issued and promulgated by FERC on changing the PURPA rules in July of 2020. You aware of those changes?
Is that talking about Order 872?
Yes, sir. You familiar with Order 872?
I've read parts of it, but I'm a long way from anywhere near having expertise on
Well,
saying what changed.
Yes, sir, I understand. You would agree with me that under that order, the FERC's final rule gives state public service commissions authority to require variable energy rates in long-term contracts or in legally enforceable obligations. True?
Yes.
And that avoided costs may be determined at the time the energy is delivered, correct?
Yes.
It's not to be fixed for a duration of a long-term purchase commitment. True?
That's right.
Right. So the idea is that the variable energy rate on a QS long-term contract may be based on transparent competitive market prices determined using publicly available price indices. Is that correct?
That's correct.
Right. And so we go on to the part that I really wanted to ask you about, and the new rule also provides greater certainty as to when a legally enforceable obligation, which we sometimes refer to as a LEO, is created, and thereby vesting a QF's entitlement to the mandatory purchase obligation. True?
Well, I will say I got tired very quickly with reading the Leo section. So I really, I can't say what it says.
Well, let me read you what I'm told it says.
All right.
The QF first under the new rule must demonstrate commercial viability. There's no issue in this case. Cherokee has done that. Would you agree?
Well, they're an operating plant, so they
can check that box.
Yeah.
So under the new rule, under these under the objective and reasonable state determined criteria, the QF is entitled to a contract or a LEO. True?
Commissioner Irvin, this is Brett Braceward. I apologize for interrupting your line of questioning there. I do want to just point out that both witness Snyder and witness Bowman have pretty extensive sections on the LEO issue as well as Order 872 in their testimony. And you certainly have a right to ask whichever witness you would like on the subject matter, but it's pretty far outside of Mr. Freund's area of expertise. So I'll stop there and just wanted to make sure everyone was aware of that as this continued.
Thank you.
Yes, sir.
So I'll wrap this up. Apparently, we're going to have other company witnesses tell us about it. But my point is that the new rule has applicability to this case. Would you agree with that?
I struggle to say what part of it would affect anything we've done.
Well, for example, it would affect how Leo is formed for a QF in terms of determining voided cost, correct?
All right, well, I'm not knowledgeable about how the new rules are speaking to, the Leo issue.
All right, well, we'll wait for another witness then. Thank you.
Yes.
No further questions.
Redirect.
Chairman Williams, Commissioner Caston.
Commissioner Caston.
I apologize. I had one more question I meant to ask and forgot, if I may.
Go right ahead.
Mr. Flynn, did Cherokee request specific voided cost information from the Duke companies?
They asked for a lot of detail, as part of this proceeding through interrogatories. Previous to that, they did ask about the development or how we developed, or I can't remember the specifics of the prior data requests, but I do remember there were requests for information.
To the best of your knowledge, did Duke provide the requested information?
Well, we definitely responded, and we responded consistent with the way we typically respond to QFs that are asking us for insight on how their rates might have been calculated.
Okay, thank you.
All right.
Questions?
Okay. Redirect.
Thank you, Mr. Chairman. Mr. Freund, just a few questions, if I could, and hopefully I muddy the waters on this less versus more, but I'm going to be the second poli-sci major to continue that joke and take a run at it. Very briefly. So I put on the screen your testimony. This is Freund Direct Figure 1, which you and counsel for Cherokee were speaking about a little while ago. Do you recall that discussion?
Yes.
Okay, and just at a high level to explain to the commission, was the objective in putting this together to explain the inputs and assumptions that the DEC and DEP used for each of the rate offers to present the most accurate and appropriate capacity and energy components of each avoided cost rate calculation that you completed for the companies and provided to Cherokee?
Well, its purpose was to provide a high-level summary that would make it easy to see which of the price quotes reflected non-dispatchable versus dispatchable tolling, PPA pricing. But it was also to provide insight on when we provided the rates relative to the time of request, and also the first year of need that was capacity need that was assumed in the avoided capacity cost calculations. And the timing of gas cost assumptions, that was showing or giving an indication of the month that was reflected as our month of avoided cost estimate.
Okay, so let's focus on those three columns just briefly. So the timing of gas cost assumption, that's a key input into the avoided energy rate. Is that right?
It is.
Okay, and so over time, as you progressed across the exhibit and you responded to each of Cherokee's requests, you used updated gas input assumptions to inform or to calculate the avoided energy rate. That's what you're showing here. Is that right?
That's right. Yes.
And what Mr. DeGrandis was really focusing on with you was the avoided capacity component of those rate calculations over time. Is that correct?
Yes.
Okay. And I think y'all discussed the first year of capacity need based on IRP. I think it's 1, 2, 3, 4, the fifth column down, and whether it's 2028 or 2026. Was that, you recall that discussion?
Yes.
And just to be clear, and I think this was what he was showing you in order, 881, 2019-881 was that the first year capacity need based on the company's IRP used in the more recent assumptions were in 2026 for DEC, and that was based on the 2019 IRP update. Is that how you calculated that rate?
Yes.
Okay, and the earliest, the September 2018, or let's call it the October 2018 offer was based on the first year capacity need of 2028, and that was based on your prior 2018 IRP, right?
That's right.
Okay, and the methodology used across all 5 of these offers was fully consistent. Is that the way you developed it?
Yes. Yes, the only point of difference would be in the case of the dispatchable tolling. We had to digest the avoided capacity cost into a different form of pricing, dollars per kilowatt rather than dollars per megawatt hour.
Okay, and I think where Mr. DeGranis may have been going with the exhibit that he presented and y'all had a discussion about was, all else being equal, the capacity value paid to the QF on a levelized basis would be higher based on a year 2026 first year of need, which was the DEC's first year of need based on the DEC September 2020 offer and the February 2021 offer, then based on the 2018 IRP, which showed a later 2028 first year capacity need. Is that generally accurate, all else being equal?
Yes.
And was it your point that there are multiple inputs and assumptions that inform that, and so you need to take all those variables into account?
Well, that's right. Yes, with the calculation that was made for the February 2021 quote, the contract capacity price got the benefit of a higher avoided capacity cost that was a result of both more years of avoided capacity costs within the 10-year term, and also the avoided capacity cost that we were assuming per year was higher.
So on the capacity side, the February 2021 offer that DEC has been suggesting is the most accurate and appropriate for Cherokee actually has a higher capacity rate than the calculation of the September 2018 offer, assuming a September 2018 LEO, as Cherokee has been advocating for, assuming the companies followed the methodology that you've used for all other large QFs. Is that right?
The avoided capacity component portion is higher because the contract capacity price is actually supported by an avoided capacity cost component and an energy value component.
Okay. And how does the total rate change based on the avoided capacity and the avoided energy component combined?
Well, the avoided capacity cost component has increased significantly. It went from $15 a kilowatt year to $36 a kilowatt year. The avoided energy cost component is a little bit tougher to relate to, but it decreased. Let's see, and we look at the Freund adjusted version of Witness Strunk's calculated energy component. Witness Strunk started out with $63. After I removed the start cost component of $20, it took it down to $43. So if we think of $43 as the avoided energy cost component based on 2018 inputs, and compare that to what we represented in the February 2021 quote as the energy component, it was $21. So the avoided energy cost component decreased while the avoided capacity cost component increased. And the increase in the avoided capacity component actually exceeds the let's see, let me look at something right quick. All right.
Mr. Witness, what are you looking at?
I'm looking at my notes.
Oh, okay.
I'm sorry, just taking me a moment here. I didn't expect to be asked this question, but I can.
That's right. I'll withdraw the question. If it's not easily ascertainable, we can move on. Thank you, Mr. Chairman. I think I have no further questions for redirect.
Chairman Williams.
Commissioner Williams.
Thank you. I apologize for joining in late, but that last conversation kind of compelled me to ask for this. Mr. Freund, one of the things that I have been doing throughout this hearing is taking your figure 1, which I like a lot, and adding notes to it. I think I'm a better graphic learner than an oral learner, so that's why I was a little bit lost in that last conversation. I wonder if it is possible for you to update figure 1 and create a new figure as a late filed exhibit that might add, where it is possible, what the Duke avoided energy value, avoided capacity value, and the avoided cost is. I understand that may be confidential in some different categories, but I'd be interested in seeing that for each of the 5 offers. Is that legally appropriate and possible mathematically?
Well, the avoided capacity costs that I calculated for the for 2018, which was represented as an alternative to the avoided capacity costs that Witness Strunk had calculated. That would really be representative for the 2018 offer that we made to Cherokee. But I could go back and do the same for the DEP offers. I would convert that to a $1 per kilowatt year basis as well. So yes, I could provide that information. I think the one thing that's missing is the energy component, because Strunk did an approximation of the avoided cost energy value of the Cherokee project. And this is something that we would normally calculate by running production cost models where we simulate the Cherokee project with its dispatchable characteristics to get a better quality representation. And so I have that for the, for example, for the February 2021 quote that we gave them.
Just to be clear and clarifying, I'm just asking for the Duke numbers.
Just the Duke numbers.
Right.
Well, I've got I can provide that for the adjusted version of what Strunk had calculated. That's my adjusted version. And I can provide that for the February 2021 price quote. I can do the same for the September, let's see. I think that maybe the September, so we made a price quote in, let me get my table.
I'll just accept. Yes.
Might I just make a suggestion? If you allow, once Mr. Freund leaves the stand, the companies to discuss it with him and confirm that we can provide what we think you're asking for here, we'll endeavor to do so. And if there's a follow-up question that we need to advise the commission on some clarification, we could do that when the hearing resumes tomorrow. Is that
That's absolutely acceptable. Just for clarity, what I'm asking for is where it's available from the Duke avoided cost data and if it needs to be confidential, that's fine. To be able to see the avoided energy and the avoided capacity cost and then the total avoided cost for as many of these proposed contracts as you all have offered on Mr. Freud's figure 1.
Yeah. Commissioner Williams, this is Bill DeGrandis on behalf of Cherokee. Just one question. We would like, as Mr. Freund provides that info, just to clarify, that would include the information he has in avoided cost rates for the dispatchable tolling agreements, those listed in the last 2 columns.
I'm asking for as much as I can get from figure 1. So yes, it would include all 5 proposals.
Thank you, one last, we would like the ability to, Cherokee would like the ability to comment on whatever Mr. Freund provides as a sub-hearing exhibit. Just to we reserve our rights to do so. Thank you. Thank you, Mr. Williams.
All right, Mr. Witness, you can step down from the witness stand. Call you next.
Thank you.
Yes, sir. Thank you. Please call your next witness.
Thank you, Mr. Chairman. The companies call witness Glenn Snyder to the stand.
Witness Snyder, if you would, please take the stand and pause to be sworn in by the court reporter.
All right, sir. Do you swear to tell the truth, the whole truth, nothing but the truth? So help you God.
Yes, ma'am.
Thank you.
Good afternoon, Mr. Snyder. Would you please state your full name and business address for the record?
Certainly. Let me start by apologizing to the commission for a little bit of the casual dress here. It's post-COVID. We're still 80-something degrees in the office, so I had to lose the jacket earlier this morning. So my apologies for the casual attire. My name is Glenn Snyder. My business address is 526 South Church Street, Charlotte, North Carolina, 28202.
Thank you. And by whom are you employed in what capacity?
I'm currently employed by Duke Energy as Director of Carolina's Integrated Resource Planning and Analytics.
Thank you, Mr. Snyder. And how long have you been employed by Duke Energy and working on matters related to PURPA implementation in the Carolinas?
I have worked for Duke Energy or one of its predecessor utilities since 1992. While I am not an attorney, I have become familiar with Section 210 of PURPA and FERC's regulations implementing PURPA through my role at the companies, and have testified multiple times before this commission and the North Carolina Utility Commission on PURPA avoided cost related issues.
And thank you, Mr. Snyder. Did you cause to be pre-filed in this docket direct testimony consisting of 36 pages?
Yes.
And do you have any changes to that direct testimony at this time?
No, I do not.
And if I were to ask you those same questions today that appeared in your pre-filed direct testimony, would your answers be the same?
Yes, sir.
Thank you, sir. Mr. Chairman, I'd ask that Mr. Snyder's pre-filed direct testimony be entered in the record as if given orally from the stand.
Mr. Snyder's pre-filed direct testimony will be entered into the record as if given orally from the stand.
Thank you, sir. And Mr. Snyder, did you have any exhibits appended to your direct testimony?
I do not.
Thank you. Mr. Snyder, I'd now like to walk you through your direct testimony to provide a brief summary for the commission. I'd like to start on pages 5 through 7 and ask you to provide a general overview of PURPA and the Act 62 avoided cost framework. Can you please summarize that testimony for the commission?
Yes, I can. PURPA rests on the twin pillars of non-discrimination and customer indifference. It requires that the price a utility pays for purchases from QFs be just and reasonable to the utility's customers and in the public interest, and non-discriminatory towards QFs. PURPA also limits the rates paid to QFs to the purchasing utility's incremental or avoided cost. This provision is designed to ensure customers remain indifferent between the cost of utility or non-utility generation provided by QFs. In South Carolina, Act 62 defines avoided cost in the same manner as FERC's regulations implementing PURPA.
Thank you. And then on pages 8 through 17, you have a section of your testimony discussing the concept of a legally enforceable obligation, or LEO. Can you please summarize that portion of your testimony for the commission?
Yes. Under PURPA, a QF can choose to sell power either as available or pursuant to a LEO at a forecasted avoided cost rate determined at the QF's option, either at the time of delivery or when the obligation is incurred. The LEO concept is intended to protect QF's right to sell power to utility under PURPA, where the utility refuses to enter into a contract or the QF and utility cannot agree on PPA terms and conditions. In my view, the LEO is also intended to memorialize the QF's commitment to sell its output to the utility at the utility's avoided cost, so that the utility can then rely on the QF's power to serve customers. In addition, the date a LEO is established is important because it locks in, either contractually or by commission order, the avoided cost rates that a utility pays the QF. I then explained that since the company's customers ultimately pay for QF power at the avoided cost rate, the LEO date should be reasonably aligned with the date when customers begin receiving that power. This limits the potential for customers to pay for QF power at stale rates that do not reflect the actual avoided cost value of the power they are receiving.
Thank you. And this section of your testimony, you also discuss how a large QF like Cherokee would establish a LEO and commit to sell their power to DEC or DEP in South Carolina. Can you summarize that portion of your testimony?
Yes. For large QFs, the companies follow a standardized process for negotiating a PPA that begins with the QF requesting avoided cost pricing from the utility. DEC or DEP then provide current avoided cost pricing, and if requested, an executable PPA. The avoided cost pricing remains valid for a period of time, normally about 60 days, to allow the QF and the utility to work to finalize the PPA. Once the parties reach full agreement on all of the PPA terms and conditions, the PPA is executed by the QF and thereby memorializes the QF's LEO to commence delivering power to the utility. This is the process the company used with Cherokee as well as many other QFs. Under this standardized process, the companies provided current avoided cost pricing and an executable PPA to Cherokee each time Cherokee requested it. But it was Cherokee's responsibility to fully commit to sell its output to a single utility at that utility's avoided cost rate, and then proceed to negotiate and finalize a PPA in order to establish a LEO. Cherokee never made any commitment to sell its power beyond its initial notice of intent to sell, and never engaged with DEC or DEP to negotiate a PPA.
Thank you. And then on pages 17 through 19 of your testimony, you give an overview of the methodology the companies use to calculate avoided costs under PURPA. Can you summarize that testimony for the commission?
Yes. DEC and DEP have traditionally used the peaker methodology to forecast their avoided cost of capacity and energy in order to set the avoided cost rates paid to QFs. The peaker methodology is designed to ensure that purchases from new QFs are not more expensive than the avoided capacity cost of a simple cycle turbine, or CT, generating unit, what we usually call a peaker, plus the utility's forecasted avoided system marginal energy costs. The company's established practice is to use the same peaker methodology to determine avoided cost rate for all QFs, whether or not the QF is a small QF eligible for the standard offer or a large QF like Cherokee. For large QFs not eligible for the standard offer, pursuant to order number 2019-881 sub A and 2020-315 sub A, the companies update the inputs used in this peaker methodology on a quarterly basis to more accurately reflect the company's most current forecast of avoided costs. Prior to the Commission's orders approving the company's avoided cost methodology under Act 62, these were updated even more frequently on a monthly basis and provided upon request by the QFs. DEC and DEP followed this standardized methodological approach in offering avoided cost rates to Cherokee.
Thank you. And then on pages 21 to 31 of your testimony, you address the timing of the utilities' respective needs for incremental generating capacity and how that impacts the calculation of the avoided capacity rate. Can you summarize that testimony?
Yes, I can. Prior to the year in which DEC or DEC's IRP identifies the utility's next avoidable generating unit, the utility does not have a capacity need to avoid by purchasing QF power. Therefore, when calculating the avoided capacity rate, the utility does not provide avoided capacity value. The utility does not provide avoided capacity value for the years before a future avoidable capacity need arises. I explained that this approach is fully consistent with PURPA policy such that QFs are paid rates reflecting costs that, but for the purchase from the QF, would have otherwise been incurred by the utility and its customers. The company used this approach when calculating avoided cost rates for Cherokee. It is also completely consistent with how they calculate rates for all other QFs. At the time DEC provided avoided cost rates to Cherokee in October 2018, DEC's next avoidable capacity need arose in 2028. I also explained that the early capacity additions identified by Cherokee Witness Strunk in DEC's 2018 IRP did not represent avoidable capacity need that Cherokee could help meet, because those additions represented designated capacity that cannot be avoided.
Thank you. And then on pages 34 through 35 of your testimony, you addressed the recent decline in avoided cost rates since 2012 when Cherokee and DEC signed the existing PPA. Can you summarize that testimony for the commission?
Yes. Avoided cost rates have declined significantly since 2012, due both to the decline of natural gas and other commodity costs, and because DEC's need for new capacity had declined and been pushed out due to new QF and utility generation over this time, along with reductions in the company's peak demand forecast. As a result, the lower level of avoided cost rates provided to Cherokee during the 2018 through 2021 timeframe simply reflect these changes and accurately and appropriately represent the company's avoided costs at the time those rates were calculated.
Thank you. And then on page 35, 36 of your testimony, you addressed the company's obligation with regard to transparency of avoided costs. Can you summarize that testimony for the commission?
Yes. Act 62 requires each utility's avoided cost filings to be reasonably transparent, to allow for independent review and verification by other parties and the commission. FERC also requires utilities to make certain avoided cost information available to QFs. In Order 2020-315A, the commission directed the companies to provide detailed information regarding updated inputs to the avoided cost rates for large QFs. Based on my review, the companies have met these obligations.
Thank you. And based on all of the testimony that you pre-filed, in your opinion, have the companies adhered to the requirements of PURPA, FERC's implementing regulations, Act 62, and this commission's directives in providing rates to Cherokee?
Yes. In my opinion, the companies have adhered to all of the requirements of these laws and regulations, including, as specifically addressed in my testimony, the calculation of avoided cost rates and the standardized process for negotiating with large QFs. DEC and DEP have each treated Cherokee fairly and appropriately as regulatory circumstances and avoided costs have changed over time.
Thank you, Mr. Snyder. Mr. Chairman, Mr. Snyder is now available for cross-examination by the parties and questions from the commission.
Thank you, sir. Cross-examination.
Thank you, Mr. Chairman. Good afternoon, Mr. Snyder. My name is Jenna McGrath. I'm from the law firm Paul Hastings, representing Cherokee today.
Good afternoon, Ms. McGrath.
Good afternoon. So I have watched a little bit of your testimony before. I'm told that the commissioner has nicknamed you the man with a plan. Is that right?
I am responsible for our integrated resource plan, and yes, so I think that moniker came from that.
Very good. So I'll warn you up front. I'm a FERC attorney usually, so if I use any acronyms or anything that you don't, that you're not familiar with, just let me know, but we probably speak the same language here. So your proper title is Duke's Director of Integrated Resource
That is correct.
Great. And have you visited the Cherokee Cogeneration plant before?
I have not.
But is it a familiar resource to you, given your resource planning by RMS that's been dispatched around 60% of the time? So does that sound right to you?
That sounds about right.
Okay. And you did say you're responsible for the integrated resource planning process, or the IRP process, correct?
Correct.
So we can get into a few more details in a moment, but just high level, would you agree that the IRP process fundamentally intends to project future load obligations and resources that Duke will need to serve them? Is that fair?
That is fair.
Okay. And to do that, you select a variety of assumptions, run sensitivities on them, go through different scenarios, and the model selects resources for each of your portfolios based on those assumptions. Is that right?
Yeah, generally I would agree with that statement in general.
Okay. Now, hopefully you agree. I think that the IRP in this case is a very important element of the conversation. Is that right?
Yes, the first year of need date is largely debated based on IRP.
Sure.
Along with.
So yes. Right. So each of the offers that Cherokee received from Duke, that capacity payment was based on the first avoidable capacity need based on the most recently filed IRP, correct?
That is correct.
Okay. And is it correct that DEC's first offer to Cherokee in 2018 did not have a capacity payment because Duke did not calculate or project a need until 2028? Is that right?
That is correct.
Okay. And I think we just established with Mr. Freund, starting in 2019, that IRP, the 2019 IRP projected a 2026 capacity need date, right?
Yes, the need date moved up by 2019.
Sure. So the later offers reflected that. So would you say with each IRP you run and each IRP you file, that capacity need date can change based on the assumptions that go into your models and the various scenarios you run?
Yes, more so the assumptions. We use a single scenario for avoided cost. So it's, yes, the assumptions on load forecast, retirement of units, amount of new units that have come online since the last IRP. All of those things can change and affect your first year of need date.
Sure, thank you. And I think you heard witness Hansen. You understand that lack of an appropriate capacity payment was one of the primary reasons that Cherokee couldn't accept your offer in 2018. Do you understand that?
I understand that is LS Power's position.
It is, yes. And I think you heard witness Strunk too. He kind of took as a given your avoided peak and off-peak energy payments from that October 2018 offer. So assuming that those are correct and we had a Leo at that date, the main issue was that you didn't have a capacity payment.
Yes, that the capacity payment is certainly an issue in this case.
Sure. But you're not recognizing October 2018 as a Leo date because Duke thinks our Leo or our rates expired within 60 days?
Duke offered, as I understand it, avoided cost rates as of September 2018, but Cherokee was unwilling to accept those rates, and that rate cannot stay open indefinitely. So yes, I think I would say that, you know, it was not, we contend a Leo was not established at that point in time, though, as Mr. Keene represented, we did provide avoided cost rates as of that date. and were willing to execute if Cherokee was willing to execute at those avoided cost rates.
Okay. Now, I think I heard during your summary, and please correct me if I misstate this, I heard you say that LEO can exist where the utility refuses to contract with the QF, or where the QF and the utility can't agree on terms to the contract. Did I get that right?
Yes, let me go back and see what I said in my summary exactly. Yes, that's generally correct. Yep.
Okay. So just to be very clear and break down how the IRP and avoided capacity costs relate, first, the IRP process determines DEC's first capacity need date. And then to calculate the avoided capacity cost, DEC incorporates capacity payments as of that date identified in the IRP.
Yeah, to be clear, that goes into the valuation process. So just out of abundance of clarity and transparency, the QF would receive a capacity payment in all years of the contract. The valuation of what that capacity is worth takes into account how much capacity value is being avoided, which then takes that first year of need. So the valuation portion recognizes the first year of need. The payment starts for the QF on the first day of the contract. They get
Sure.
a payment on day one.
Okay, and that's as a result of the capacity payments in the years that do have a capacity need being levelized over the term of the contract. Is that right?
That is correct.
Okay, thank you. I'd like to clarify some of the economics at play in this proceeding. Duke is an investor-owned utility, correct?
Duke is an investor-owned utility.
Okay. And its rates to its customers are cost-based, meaning that customers pay DEX costs plus a return on equity. Is that right?
A regulated return on equity and regulated costs, yes.
Sure. And so DEX investors earn a return on DEX rate base, including transmission, power plants, distribution wires, and the like.
Yes, what's allowed in a rate case is exactly what you just said.
Okay. But DEC would not earn a return on PURPA purchases. Is that correct? Those get passed along just straight as a pass-through to the customer. Is that right?
Yeah, just like our fuel costs, it's a purchase power expense like natural gas or coal or solar, or in this case, Cherokee. Those go through and are a direct payment from our customers. So they pay it dollar for dollar.
So Duke's shareholders would get a return on generation facilities built by Duke, but not on capacity supplied by a QF. Is that correct?
If allowed by the commissions, yes.
Okay, thank you. I'd like to try to introduce Exhibit Snyder 002. I'm going to try to share this here for a moment. Actually, I'll do Snyder 001. I apologize.
Ms. McGrath, I apologize for interrupting.
Sure.
Have those exhibits been circulated to the parties, and if so, at what time? I'm trying to find them in my email, and I'm not seeing that they have.
Okay. Let me see. I did email them right before. It was a large email, about 18 megabytes. So if you have filters, I would have filtered that out. I do have that going to. Okay, yeah, that's what I was explaining. I believe I missed you. I did send it to Ms. DeMarco if she can confirm she received it. I'll open up my email really quick and send that to you too, Mr. Breitschwartz.
You can forward it on.
I apologize.
I haven't received it.
Okay.
Thank you. So
I have not received it.
Okay.
Okay, let me take a look here.
Does
Does the witness have it?
No. And I know
Apologies.
that's right. I know we're working diligently on moving the hearing forward. Is it an order or something the witness will be familiar with, or is it a document he's never seen before, just for my informational purposes of whether we
I
need
would
to?
expect he's seen it before, but I can't be sure. It is showing as sent in my sent box. Here, I'm gonna delete one that's very large and then retry it. Apologies for the delay here.
Ms. McGrath, since apologies for that, because I think it might send faster over our network. If you could let me know the time. I don't see that I have anything from you.
Okay. The time
Today,
says
but if it was sent earlier than that.
2:35 Eastern.
Sorry, could you repeat that?
2:35 Eastern.
No, I don't think it's come through yet, so apologies for that.
Okay. Yeah, it did. It had one 10-megabyte attachment, and I am certain that Mr. Snyder has seen that. So I will delete that and try again.
Attorney McGriff, this is Joanne Wessinger
Yes.
with the commission. Tell me again which cross-examination exhibits you wanted for Mr. Snyder. Which number?
I was just going to put up Snyder 001.
Got it. Thank you, ma'am. We'll circulate them to the parties as well.
Okay, thank you very much, and I apologize for the inconvenience here. Tried to send it right before Mr. Snyder went on like everybody else, but this had a particularly large attachment, so I apologize.
Mr. Chairman?
Yes, ma'am.
We have submitted that. Staff has sent that also to all parties, Mr. Chairman.
All right. I guess we need to wait until the parties receive the document.
I've just received Exhibit 1 from Ms. Wessinger Hill, so if Ms. McGrath can put that on the screen for Mr. Snyder, I'll ensure that he receives it in his email as well. And if we have any concerns or he needs time to review it, we can ask for a further pause, but I don't want to belabor this.
All right.
Sure.
How about we do this? Let's take a 10-minute break. Come back at 3:10, and hopefully we'll be prepared to proceed at that time. We're in recess until 3:10.
Thank you.
Good afternoon, ladies and gentlemen. We're back in docket number 2020-263E. We're going to take roll. President of the hearing room are Commissioners Thomas, Powers, C. Williams, Belzer, and J. Williams. Joining us virtually are Commissioners Irvin and Caston. All right. Counsel for Cherokee, are you ready to proceed?
Thank you, Mr. Chairman. Yes, I believe so. Mr.
All right.
Birchworth confirmed receipt of those exhibits. So if it's all right with you, I'll proceed.
Yes, ma'am. Right before you do, just want to remind everyone that we have a 4 p.m. business meeting, and so we're going to take a break then and then come back.
Okay, thank you, Mr. Chairman. Well, let's resume. Apologies for the technical difficulty there, getting those exhibits over to you. I'm going to share my screen here in just one moment. Can you see this page from what says down here, the Duke Energy Investor Update from summer 2021, Mr. Snyder?
If you could enlarge that for us, ma'am, we barely can see it in the hearing room.
Can you see that?
I can see that, yes.
Okay. So I won't linger on this page. I just wanted to make sure I understand sort of the direction and goals of a company. Mr. Snyder, are you willing to accept that this is a publicly posted presentation on Duke Energy's website for its investors?
Subject to check, but yes, I'll agree.
Certainly, okay. So it looks like there's a really aggressive CapEx program at Duke, and you have about $59 billion in capital expenditures over the next 5 years planned across the Duke companies, correct?
Yes, I'm assuming that's across Duke Holding companies, all the utilities,
Sure.
other businesses, etc. I don't know the context of it, but that is not a DEC and DEP, as I understand it. It's a holding company.
Of course.
Okay.
Yes, Mr. Snyder. I understand it's consolidated, but DEC and DEP would be part of that plan, correct?
Correct.
Sure. And just to go a couple pages over, your investors are probably very interested in your CapEx plan at DEC, and the IRP is probably a significant part of that. That's why you present the results in your investor materials. Is that right?
I wouldn't say that's the only reason. I think investors are interested in what our resource plans are for CapEx, for types of generation we're adding, for all sorts of reasons. But yes, we do show our resource plans in investment materials.
Okay. So I just wanted to ask you, since you are the witness and deeply involved in the IRP and a few proceedings, about some of the assumptions that you use in your IRP. So first, just to be very clear, even though DEC and DEP are sort of under the same holding company structure and share a geographic boundary, they are considered completely separately for purposes of resource planning. Is that correct?
They are separate utilities with their own resource plans.
Understood. And each has its own 17% reserve margin. Is that right?
That is correct.
Okay. And currently, these IRPs do not model availability of neighboring markets resources. Is that correct?
In the calculation of the reserve margin, it does take into account neighboring utilities' ability to help meet peak demand when we calculate our 17% reserve margin, but we do not dispatch neighbors for our energy calculation.
Sure. So you wouldn't be able to, select a resource in one of your portfolios from a neighboring utility, is that right?
Yeah, in general, IRPs do not cite resources, but select generic resources, agnostic of site in general.
Okay, so DEP doesn't consider DEC as resources, and DEC doesn't consider DEPs.
For capacity planning purposes, they maintain separate. Their JDA is a joint dispatch agreement that has non-firm economic dispatch between the utilities that is taken into account in the IRP.
Okay, thank you. Now, I'd like to ask you about whether your resource plans contemplate taking power from Cherokee past the date of its contract expiration in 2020?
No.
Okay. And that was also true for the 2018 IRP, right? The Cherokee contract was assumed to expire in 2020, so it wouldn't have been included or modeled past that 2021, January 21 date.
It was in until the expiry of its contract, yes.
Okay. So you did not model the Cherokee plant at all as an option beyond December 31st, 2020?
That is correct.
And Cherokee's outreach to attempt to form a legally enforceable obligation with Duke in September of 2018 didn't change that at all, correct?
No, they never obligated themselves. They had an intent.
I understand that's your testimony. Okay. And right now, even though we're in this proceeding with Cherokee attempting to assert its statutory right to put power to DEC, you are not including Cherokee in the IRPs, is that right?
It is not. Beyond the 2020 date. Yeah.
Okay, so it is right, but it's not currently in the plan.
That's right. That is right.
Okay. So I'm very interested in how you treat third-party contracts for purposes of modeling in your IRP. And this is a big exhibit that I'm hoping we can agree. I'm sure you've looked at this about 1 million times, but I'm going to pull up the 2020 DEC IRP. Let me share screen. So do you recognize this document, Mr. Snyder?
Could you make that larger, Ms. McGrath? I'm sure you're going to hear that from the hearing room.
No problem. Let me see if I can get it all on the page here.
Yes.
How is that?
I see that. Yes.
Okay. And this is chapter 13, Mr. Snyder. You see, this is the section, and I believe you testified to this in the IRP proceeding. This section is very relevant to calculation of avoided capacity costs because it determines the first date of avoidable capacity need. Is that right?
That is correct.
Okay. And you're looking at this process of determining the first avoidable capacity need. It looks like you have two categories of that you take a look at for resources, and they're designated and undesignated. Could you please describe to me the difference between those?
Yeah, you can think of it as you pointed out earlier, your resource plan looks at how your needs change over time due to increases in load growth plus retirement of units will create a need. And then existing resources can help meet that need along with designated resources that are not yet in service but are committed to. And we go into some definition there of what that means. And then the model, when there's still a need beyond what's existing in the ground today or about to come on into service, there's still an incremental need. Then, as you pointed out earlier, the model selects, or we pick incremental resources. If those resources are not designated or approved at that point in time, those are called undesignated. So that undesignated resource is an avoidable, where the existing and designated are not.
Sure. So designated is not avoidable, undesignated is avoidable, correct?
Correct.
Okay. Now, the next page describes how Duke looks at contracts when it's doing its modeling here. And I see three designations. You know, there's designated and undesignated. And is it correct that you treat this mandated category as a designated that is avoidable resource?
No, not in South Carolina. We do not.
Okay.
That was the subject of the 2019 avoided cost proceeding with some debate with the ORS, and we removed that from the unavoidable and take those out when we calculate the first need. So those become avoidable.
Okay. So this is sort of left over from, this is a holdover from the North Carolina proceeding?
The mandated portion, and it really refers to a mandate under, it's becoming a bit mute because there's not many mandated that aren't already either designated or clearly fall into undesignated, but it was when you were required to do certain programs, solar additions under solar programs that you were going to go out and procure. Are those avoidable or are those not? There was a fair amount of testimony back and forth in the South Carolina 2019 avoided cost hearing, where we ultimately at the end of that order pulled those out per the ORS. I think it was witness Ori's recommendation, but they're, for all material purposes, there's not much that falls into that. So it really doesn't have much bearing on this case.
Of course. But this designated category, these are contractual obligations that you are currently under. Is that right?
Those would be one resource that would be undesignated. Yes, not the only, but yes.
Okay. And if a QF, I understand that you didn't believe that Cherokee formed a LEO, but if a QF did form a LEO that you recognize, you would have to include that under the designated resources, wouldn't you?
No.
Well, it's a legally enforceable commitment, and I thought that you indicated that committed resources would be included in your IRPs.
That is for legally enforceable is for PURPA terms in terms of when you establish the pricing. But we've had several people establish LEOs that never come to fruition. So I wish it was. I mean, I wish the commitments were strong enough, and I do think that's where the world is evolving, is to make these commitments strong enough for me to count on them for resource planning. We count on them in a resource plan when they are an executed PPA. So I actually have a LEO does not give me a legal right to that capacity. Many people have LEOs and then walk away. A signed PPA that has force and effect of contract law does give a resource planner, from a planning perspective, rights to that energy and capacity. So once a contract, a PPA is executed, and to the extent the PPA does establish a LEO, we're in agreement there. But a non-contractual LEO, while it does set a price at a point in time, I would not feel confident as a resource planner to put that energy and capacity as a designated resource. It would remain undesignated until the PPA was executed.
Okay. Those folks who walk away from LEOs, would you say those are typically projects that are in development and abandoned?
Or people that cannot sell at avoided cost rates?
Okay. So Cherokee, you didn't recognize the Leo. It's not in your modeling past 2020. So basically, in terms of the model, and I will stop sharing my screen right now. I apologize. In terms of the model, Cherokee basically falls off the face of the earth, right? You act like it doesn't exist.
From a planning perspective, we do not count on its energy and capacity until we execute, and if and when we would execute. I think I point out in my testimony, at the end of a contract, they could close the facility, they could sell the facility to another utility, to a muni, to a co-op. They could wheel that power under to an, as was evidenced with DEP. That DEP could have easily been SCANA, now Dominion, Southern Company. So I have no, think about the commercial contractual rights to that capacity. I have no, as a utility, no contractual rights to that capacity and energy until such time as we've executed a legally enforceable contract.
Okay. So I saw in your testimony, also with respect to Leos, that you think that a Leo must be reasonably aligned with the delivery date. So if Cherokee tried to create a Leo 2 or 3 years prior to a new contract, you wouldn't recognize that?
We did. We would have. Had they actually, I think it was 30 months in advance, had they executed a contract or made a commitment, as Mr. Keene spoke about, if they said, we'll accept your pricing and we're going to work towards commercial terms and conditions, and we're ready to execute a contract, we would accept that as a Leo. We're not saying that 30 months is too far in advance, at least in this case, not.
But the QF has to accept your pricing at that point, correct?
Yeah, the QF has to demonstrate that it can sell at the avoided cost rates to establish a Leo, because we're not able to sell above, to pay above avoided costs.
Correct. But you calculate those avoided costs, right?
Yes. There's a tremendous amount of testimony prior to me on that, but yes.
Mm-hmm. And if the QF doesn't think you calculated them correctly, it doesn't sound like they can enter into a contract with you.
If they don't think we've calculated them correctly, you're right. They may not want to enter into a contract. I would say in this case, had they thought they were incorrectly calculated in September, they could have filed something with this commission in October of 2018 and said, let's look into the calculation of these. That did not happen until, over 2 years later.
Of course. We understand when Cherokee attempted to form the Leo, purportedly form the Leo, I'll say for you, you realize that the relevant avoided cost order in effect at the time required large QFs to negotiate their rates, correct?
No, I don't think negotiating the rates. I think Mr. Keene was very articulate on that. It's not about negotiating the rates. It's about negotiating the form, function, things like credit support, indemnifications, force majeure. There's many terms of a commercial contract that need to be negotiated. In the case of a PERPA QF contract, the company has no room to negotiate. It offers its full avoided cost rate to the QF. And then the QF either accepts that as a reasonable or not. But we can't negotiate up or down. We offer our full avoided cost rate to all QFs in a standardized process. So QFs of equally situated QFs that come at the same point in time are all getting the same price. We're not negotiating, one price with QFA and another price with QFB. We're simply offering them our full avoided cost prices in a consistent manner.
Okay, Mr. Snyder, I'll enlarge this. And I would just, I would ask you if you do recognize this docket number, 1995 1192E.
Yeah, and the one in May 12th of 2016.
Right. So this is the avoided cost schedule that was still in effect right around the end of October 2018, correct?
You mean the standard offer, 2 megawatt and under rate?
This is the word that was bid established that. Is that your understanding? Okay.
Yeah, my understanding is that is the small QF rate eligible to 2 megawatt and under QFs that was stipulated in May 12th of 2016. That is my understanding.
Okay. I was hoping you could read this piece down into the next page for me here. I'll scroll back up.
All rates for QFs above 2 megawatts or otherwise ineligible for the standard tariffs shall negotiate under the PURPA Act of 1978 and Federal Energy Regulatory Commission's implementing regulations.
Okay, you see where it does say that rates shall be negotiated, correct?
Yes, I see that.
Okay, I'll stop sharing. Thank you, Mr. Snyder. So in terms of modeling, because Cherokee didn't accept the avoided cost pricing that you provided, and because its contract expired at the end of 2020, your models did not compare the cost of continuing to take power from Cherokee as opposed to Duke building a new plant to replace it, right?
Models for what? Are we talking avoided cost? Are we talking IRP? Could you be a little more specific? Because we do a lot of modeling, and the modeling has some very specific aspects for the docket in which you're speaking of.
Mm-hmm. So is there any scenario from the docket in which I'm speaking in which Cherokee is modeled past 2020?
I think Mr. Freund talked about modeling in our dispatchable PPA offers, the specific Cherokee as in his 10-year dispatchable price offers. So in that context, they were, but in IRP space, they are not, as I explained earlier, since we don't have a enforced contract to depend upon.
Okay. So there was no way for the IRP to compare the cost of Duke building a new CT, for example, and versus a new PPA with Cherokee, right?
Really, that's sort of the whole point. Is there is a pretty strong link in that the peaker methodology actually is what you go through in the IRP, right? So the cheapest capital resource in resource planning is a peaker. And then you select something different than a peaker if it warrants paying an incremental capacity payment and it gets selected. So everything has to pass the peaker method, whether that's energy efficiency programs under the utility cost test, whether that's solar getting selected. In essence, in not exactly this way, but it in essence passes the peaker method. And so to the extent the IRP is aligned with the cost of a peaker, I would say it didn't select Cherokee as a selectable option, but that's what's used to say if Cherokee was cheaper than the peaker method, which is implicit in the IRP, and they took they would be able to take and accept power at our avoided cost, and then we would put them in the IRP. By them not establishing to be able to sell at avoided cost, it's unlikely it would be selected in the IRP because they're above the peaker method.
Okay. So are you equating the cost of building a brand new peaker with the cost of taking power from a QF under a PPA?
Under the peaker method, we ascribe, when there is a capacity need, the full new build cost of a peaker we will pay to the QF. And in addition, the full marginal energy value. So the systems we dispatch from the least expensive to the most expensive throughout time. And we give the full marginal energy value plus the new build cost of a peaker. And that's how the rate is established. And I go through some of that in this testimony. I go through it extensively in some of my avoided cost testimony.
Sure. And perhaps I was not clear. You were talking about the avoided cost rates, but the date of first capacity need is extremely important. You recognize because you don't get capacity payments in years that you don't have, that you do not have a capacity need, correct?
Again, the valuation does not credit the capacity payment the QF needs until there is a capacity need. And that has been heavily litigated in both North and South Carolina with extensive testimony that agrees with that approach. So beyond this proceeding, which we're touching on it, there is deep testimony in both North, South Carolina, and PURPA has also made it clear that unless there is a capacity need, you should not ascribe capacity value, or you're paying for capacity. Not you, the customers are paying for capacity twice, hence violating the but-for indifference principle under PURPA.
Right, but it seems like the whole system, based on the fact that a contract isn't modeled past its expiration, along with this idea that a LEO does not constitute a sufficient commitment, means that by the time that Cherokee would be able to put capacity to Duke, you will have already replaced that capacity with your own. Isn't that correct?
No, not. I mean, that's that totally ignores the DEP. We, as Mr. King pointed out, effectively they could bid into the RFP, but they were also afforded capacity pricing that had no zeros in it for DEP. So even the DEP example of the prices had an immediate capacity need under QFs. We paid many QFs an immediate capacity for DEP. So there's an example of where QFs were getting an immediate capacity need. Further, I think it's important to note that QFs, while they are PURPA QFs, they are also wholesale market participants. So should I have, for example, an RFP for new capacity, the QF can elect at its discretion to bid into that RFP for new capacity to the extent it is uncontracted and able to bid into that. So there's plenty of opportunity for the QF, whether through PURPA or non-PURPA, because again, at the end of the day, PURPA is a designation, a special designation for a wholesale market participant who can sell either under PURPA or can sell non-PURPA as a wholesale power provider. So Cherokee, in this case, it was demonstrated they had the ability to sell their power both ways. They attempted to sell it both ways. They had opportunity in one utility, opportunity in the other. They attempted to sell it both almost simultaneously, which again, I don't know how you establish a LEO with two utilities simultaneously. But that is not correct, that they don't have an opportunity to sell their capacity.
They didn't have the opportunity with DEC, and I think you understand. Well, I'll ask you that. They did not have the opportunity to be compared against for example, the Lincoln CTs that you're building, your models didn't look at the Cherokee PPA and the Lincoln CTs and say the Lincoln CTs are preferable. Is that correct?
The Lincoln CTs received a CPCN that was fully litigated that looked at the cost effectiveness, and it's actually built below new build CT cost. And what Cherokee is saying is they can't sell at new build CT cost. So it is, it's a little bit apples and oranges, but that CPCN was received well before Cherokee approached us. And as I said, Cherokee may or may not be there in 21, 22, 23 when the Lincoln CT was.
Right. You understand that's the point, right? Cherokee did not and would not have approached you before you got the CPCN. That resource becomes mandated, 5 or 6 years prior to its operation date, correct?
Yeah, that resource had a CPCN that was fully litigated. There were tons of extenuating circumstances that made that a very good deal for customers. It's one of the most efficient CTs in the world, being put in by Siemens. Their state-of-the-art, most efficient CT done at a substantially discounted price. I'll just leave it at that and not want to get into confidentiality. And so there's a full record on that. And if Cherokee had an issue with the issuance of that CPCN, they could have intervened at that time. I can tell you it was something that the commission found very compelling and issued the CPCN, fully aware of Cherokee's situation when that CPCN was issued.
Understood. Let's move on to, I want to ask you a couple of questions about how you treat loads for purposes of resource planning.
Attorney McGrath?
Yes.
I'm being informed that my live stream producers are going to need some time to flip the live stream for our 4 p.m. business meeting. I'm going to ask for you to pause at this place in your cross-examination and allow us to prepare for our 4 p.m.
Yes, Mr. Chairman, thank you.
All right, we're in recess until we complete our business meeting. We're in recess until 4:40.